Why don't you go see your boyfriend?
Yeah, he got a nice room. You won't have it long. He left a call for 7 a.m.
Listen properly.
Can you please look up this site?
See if we can figure out something.
Hello. Greeners, good to see you. First in chat. Nice to have you here. Hey, Lisa. Hey, Steve. Hey, Shelby. From NC. Where's NC? North Carolina. Hey, Tish. Okay, so I didn't get to catch up on... So my hair's crazy. I'm just going to say now, before anyone asks if I'm okay, I'm fine. My hair's crazy. I had to use... I have like... I'm pretty convinced it's psoriasis, but I went to a dermatologist and she said it's not psoriasis, and then prescribed shampoo called Psoridin for psoriasis. Anyway, I had to use it and it's got zero conditioner, and I wanted to just let it breathe and not have like oils and conditioners and whatever. And now it kind of looks like I've been writing all morning, so I look like I've just climbed out of the writer's hole where blank pages go to die. We were supposed to catch up on the rest of the hearings yesterday. However, I did not get a chance to, and I hopped in and listened for a little bit, and it's quite boring. It goes on for, we got to just over 7:20-ish, and it goes to 7:35. It's about 15 minutes. And I just don't think it's the way to start the day. Hey, pizza, how'd you for lunch? Not you, but you. Oh man, my hair feels like straw if I don't use conditioner. Yeah, especially, so I do curly girl, which, as I'm sure you know, with hair feeling like straw, is like an extreme amount of conditioning, oils, etc. to make it curl. But I just can't do it because, especially when I get anxious, I like scratch the psoriasis to the point where I land up with sores, and I'm there now. I've got a sore at the back here, somewhere here. I've got sores here. So I just needed to leave it and let it be wild. And it is wild indeed. I also stopped straightening. I stopped straightening mine because when I was 18, for my 18th birthday, I think I got a drum kit because I was a drummer, wannabe drummer. And I sold it when I turned 18 for my GHD hair straightener. And I used it like every single day to the point where my hair seemed to be naturally straight. And then I just decided on a whim, let me try curly girl, but man, it is such a mission. So I just do my own version of it, and surprise, this is without conditioner or anything. My hair is super curly, which I should have known because my hair was crazy curly pre-hair straightener. Also, I'll have you know that you can't see it today, but the hair straightener that you saw in the stream the other day that was resting on the table, that is the same one I bought when I was 18. I'm now 34. They've obviously changed how they make it now because they die a lot faster, but I am hoping that that one just stays there, like stays alive for as long as possible, given how old it is. Judge Simpson has just gone live with a PCC, probable cause conference, and I am pretty sure it is the man who allegedly killed the Brazilian woman. However, I think his name's Hajir, the veteran. I just don't remember where I wrote it. I have a competency hearing here. What I need to do, actually, in reality, is I need to have a notebook / calendar for court stuff. Because I have it all over the place. I have here, okay, that's 7/25. Judge Simpson, 11 June, July 9th. July 11th. Are we expecting Heenan today? I was just listening for Judge Simpson. Someone said something, and I thought it was the other court. Steve, do you remember when Heenan's next one is? Alice, when is the sub sit with Judge Boyd? I'm so interested to see how she handles it. I had it on Monday. I can show you while we wait. Subset I was expecting in the Park Lakes one didn't show. No surprise there. And Alice, I think you are the same person who asked me to please do the Judge Simpson car crash. Was that you? Do I have the wrong person? If so, I had his surname wrong. I was editing it again this morning and listening to it for the 579th time. His surname isn't Hall. It's something like... Let me not get distracted. She says distracted. I'm just trying to find the sovereign citizen. Why don't I have him? So basically what happened was I had a bunch of court things that I had started editing, and then that was around the time my computer kept saying iMovie was using too much everything. And so because I couldn't export, and one of the things had exported badly that was live, I just panicked and deleted everything. Now I've lost it. Oh, man. Is it this one? So dude with long hair, I had him down as Casanova. Casanova. Is that his real name, though? Well, he's a sovereign citizen. Also, I made a post about the ultimate sovereign citizen. Oh, here we go. Found him. I will share that soon. But it is, I've got, I think, like 8 hours. Okay, I think it's this one. June 24th.
welcome. How I can help them with.
Wait.
Awesome.
It's
All
right.
right, thank
Just
you.
saw him.
For any or whatever I roll, e-file.
Before I pass it over, Mr. Come
His name is
forward.
Casanova.
Yes. All right, so Mr. Casanova, Mr. Bach is going to be your standby counsel. And that's someone that if you have questions, you can ask him legal questions or what you may have.
Thank you for your consideration.
All right.
Uh,
And he informed me you wanted to place something on the record?
Yes, for the record, I wanted to make it known that I'm here on special appearance under threat, duress, and coercion.
All right, who threatened or coerced you to come to court?
The county of Bear, Texas.
How
State.
so?
Well, if I don't come here, then warrants will be placed, which I will be kidnapped and held hostage, and I do not want that. So that's why I'm here under special appearance to clarify any misunderstandings and to let it be known where I stand on the record.
Okay. Is there anything else?
I said everything that needed to be said.
Okay. All right. So what we're going to do is we're going to recall your case in 1 month. It's going to be a discovery setting. So that's to make sure that you have all the information that the state has concerning your case. Do you understand?
I do understand.
All right, Ms. Ferguson, if I can have a 30-day reset for Mr. Casanova. And after you receive all the discovery, then the next setting is going to be a plea deadline date. The state will tender an offer to you at the next setting. And then I'll give you your plea deadline date and you can accept the state's offer, come to an agreement or not. If you're unable to come to an agreement at that time, it'll be scheduled for jury trial.
Thank you, Ms. Boyd.
You're welcome. Any other questions?
I have no further questions.
All right, so Ms. Ferguson is going to give me a date and then you'll sign it. Mr. Bach will sign it to signify when you're to come back. All right.
I appreciate your time.
All right, you're welcome. And thank you for dressing appropriately for court. What date, Ms. Ferguson? All right, so we'll be back on July 29th. All right, once you sign the reset form, you'll be excused. Yes.
If something were to come up and I need to maybe reschedule that date, is that a possible thing to
You'll
come
need-
up ahead of time?
You'll need to speak to the court coordinator and they will let you know. I will tell you the rescheduling of cases. Are you in the hospital? You're not in the hospital, you need to be here.
Okay,
You understand?
so pretty much no excuse, be here.
Yes. All right, thank you.
Thank you.
All right, I think that's our last case for the day. Is that correct? All right, thank you for coming over, Mr. Bach.
Yes, Judge.
So that was the first one. Hi, Evie. I sent you about a bazillion proof of life checks. I was on the verge of going there myself to do a proof of life check. A little bit of movement in court, but I just want to see if I skim July 29th. Judge Stephanie Boyd, live. July 30, July 29th. Did you hear if they said afternoon or morning?
You need to be here tomorrow with an attorney. Do you understand? I'm sorry, what?
Let me see if ChatGPT can help me with this. Does the judge call Casanova at all in this? Probably going to say, the video is too long for me to look at. Encountered an issue. Okay, I'm just going to skim the transcript. Michael, motion. Need to be here tomorrow. Daryl Payne. Okay, I'm not gonna be able to skim through that now. My plan all along was to make you come here. So there's a slight chance that I might be traveling in October, and I was thinking it may be the UK, and I was like, oh my God, I'm going to meet Evie. But it's most likely Amsterdam. Also, if I can get my butt together and get videos posted, then it'll be a lot more chill because we get married the month after. But then I was looking at the map while I was looking at accommodation and stuff to get a budget going, and I saw like Amsterdam is so close to the one edge of the UK. The problem is that despite my heritage, it is difficult for me to get a UK visa. And now it's obviously difficult for Evie to get into Europe because of Brexit. I can't see this name. I've got the whole transcript. Let's go YouTube transcript. That was a loud bang. My internet seems to be a bit shifty today. Also, when court does come back in the stabbed in the heart thing, it's going to be an hour before the jury gets there. So we may very well, not that one. We may need to listen to some borings before then. Okay, copy entire transcript. ChatGPT. Nice Kurlo, you want to come over? Okay. Casanova is who I am looking for. Also, I absolutely love that people have been sending me court things that they would like me to cover. It really helps because I'm still a one-person show. There's no Casanova in that one. I'm a one-person show, and it's quite difficult to keep tabs on all of the courts. I really want to see if I can find this guy. I should really just have something on for us to watch in the meantime. Actually, I do. I saved. Hey, Jeannie. Haven't watched any of this Stabbed in the Heart. Okay, well, I have something that we can watch. I put a playlist together of recaps that we might not get through all of it. But I'm going to start on the one that I feel covers it pretty well.
Good morning, ladies and gentlemen. It's been a few days for some, so I just want to begin by reintroducing ourselves to you. My name is Shannon Buckingham. With me throughout the course of this trial is Jeremy Kuzman and Jason Haran, and we represent the Commonwealth in this case. In this case, you're going to hear about Christine and Michael Ricci. The Riccis lived in Marshfield. They have 3 kids. Angel is the oldest, and Angel is not Michael's biological child, but you'll hear from Angel that Michael was his dad. The middle son is Michael Jr., and the youngest child is Sophia. And you will hear from them during the course of this trial. You're going to hear about Michael. Michael grew up in Hyde Park. Michael was a military vet. He spent 22 plus years with the Boston Fire Department. You're going to hear about the defendant, Christine Ricci. She was, for all intents and purposes, a stay-at-home mom, but she also taught Zumba, and around the time of this incident, she was taking classes at Quincy College. The Ricci family was a seemingly happy suburban household. But ladies and gentlemen, we never know what happens behind closed doors inside a household, do we? You'll hear throughout the course of this trial from people inside the house and outside the house about how the Ricci household changed over the course of time, how the defendant changed, how Michael changed. You hear about the major turning point in their marriage that occurred in the fall of 2018. Michael had an affair. It was a brief affair, but it was an affair with another woman. And the defendant knew or found out about it. For a short period of time, the decision was made that Michael was going to leave the marriage, possibly leave the household. But quickly, the decision was made for them to stay together and work on their family and stay together as a family. Michael messed up. But from the time that he told the defendant about the affair, he did everything he could to try to make things right and keep his family together. He worked on himself, he went to AA, he worked on his relationship with his children and his wife. He did everything his wife asked him to do. The defendant, on the other hand, continuously talked and focused on the infidelity for over 2 years. For over 2 years, her inability to get over that affair increased. You will hear testimony throughout the course of this trial from witnesses about verbal and physical altercations by the defendant against Michael. You will hear witnesses describe how the defendant would control Michael. They will tell you about seeing black eyes, fat lips, scratches on his face, and a broken nose. You'll hear that the night in question, January 28th, 2021, is not the first time the defendant brought a knife to an argument. This affair was like a pot of water simmering on a stove. And over the period of time between 2018 and January of 2021, the defendant continued to turn up the heat on that pot by bringing up that affair over and over until that simmering pot of anger, jealousy, and control boiled over on January 28th, 2021. So January 28th, 2021, it's a wintry Thursday. There was still snow on the ground. Michael was home that day. You will hear that his work schedule was a work 24 hours on, get 2 days off, work 24 hours on, and get 4 days off. And so on this day, Michael was on the 4-day stretch of having some days off, so he was home. The defendant was home. Their daughter, Sophia, had gone to school and was home in the afternoon. Michael Jr. wasn't actually residing in the home, but he was close by and available. On this particular afternoon, Michael goes to Dunkin' Donuts in the afternoon, gets a coffee, comes home. He's doing some shoveling outside before coming into the house, meeting the defendant, his wife, in yet another argument. The children will testify and tell you that arguments were frequent in the household and that arguments were always about the same thing, the affair. On this particular day, Sophia will tell you that she could hear her parents arguing when she was up in her room after school, but that was pretty much normal for her at that point. On this particular day, it was particularly loud, and she did everything she could to try to tune them out. Until later in that afternoon, when her mother, the defendant, yelled her name, yelled for her to come down. Sophia comes down the stairs, goes into the area in between the dining room and the living area to find her dad on the floor and the defendant standing over him. The defendant tells her to call 911. Sophia calls 911. You're going to hear the 911. You're going to hear Sophia's testimony about what she recalls that day. The Marshfield police arrive at their home on Moraine Street. They're the first ones to arrive, you'll hear. And when they arrive, the defendant tells the first officers that Michael suddenly collapsed. So the officers that arrived begin to tend to him by giving him CPR. And almost a few minutes later, paramedics arrive from the Marshfield Fire Department. And they take over care of Michael, continuing with CPR, trying to resuscitate him and get him in a condition to take him to the hospital. When the paramedics put Michael into the back of the ambulance, they again try to stabilize him. And it's at that point where the paramedics discover, after cutting away his shirt, that Michael has a stab wound, a deep penetrating stab wound in his chest. When they remove the clothing, you'll hear, they find another injury, another wound to the rear of his arm near his shoulder. The paramedics immediately advise the police, who are inside with the defendant. And it's at that point, and only that point, you'll hear that the defendant tells the officers she had been in an argument with her husband, with Michael. She tells him she was scared, she grabbed a knife to scare him, and that when he lunged at her, the knife just went in his chest. Throughout the course of this trial, ladies and gentlemen, you're going to see those injuries. You're going to hear about those injuries. You're going to see pictures of Michael, how tall he was, how big he was, where those injuries were on his body. You'll hear that there's more than one stab wound. There's two, but there's in fact 3 injuries that are noted on his body. The stab wound to his chest, the wound to his shoulder or the back of his arm, and what will be described to you, I expect, as an incised wound, which is a large scratch along his back. You will see that there were 2 knives located in that house that day that had Michael's blood on the blade. The first was located on the floor by where his body lay, where he was laying when first responders first got to the scene, and one in a box on the dining room table with several other knives. You will see pictures of those knives. You will see pictures of the house and where those items were located when the police were at the house that particular night. You will hear from a medical examiner in this case more about that fatal chest wound and what the details of that wound, how deep it was, what kind of injury it caused, what damage it did to Michael's body, and what resulted in his death. We ask, ladies and gentlemen, that you listen carefully to the evidence and keep an open mind. And that's something you're going to hear us say, you'll hear the judge say, you'll hear everyone say it again and again throughout the course of this trial, but it is paramount in this type of a case that you listen carefully and keep an open mind. And that you not forget that you, as a group, bring to this case your common sense and life experience when you evaluate the evidence. And we ask that you do that as you continue to listen to the evidence in this case. And the evidence will tell you what happened in the Ricci household that night on January.
Okay, so now they have rested their case. The the state Commonwealth has rested their case, and we are jumping into day 6. We're a bit behind, and a little bit more than I like to be.
Ms. Ricci is present. Counsel, please state your name for the record. Please start with the Commonwealth. Thank you. Good morning, Your Honor. Jeremy Cousin for the Commonwealth.
Okay, heads up, I want to test the volume situation.
Morning.
Shannon Buckingham for the Commonwealth.
Good morning.
Jason off the Commonwealth.
Good morning.
Joshua for Christine Ritchie.
Good morning.
Good morning, Your Honor. Laura Berry for Ms. Ricci.
Good morning. Good morning to the lawyers. Good morning to the defendant. I sent you last evening a draft of the jury instructions. I want to sort of bring you up to date with where I am with regard to other issues that lingered from last night. Between last night and this morning, I have reviewed the testimony of Sophia Ritchie in regards to her accounts, most specifically of the 1/28/2021 event that led to the death of Michael Ricci Sr. That review consisted of her accounts of what happened on January 28th, 2021, when she returned to the home after school at some point on or around the 2 p.m. hour, and up until including the events of finding her father on the floor. Defendant is entitled to a self-defense instruction if any view of the evidence would support a reasonable doubt as to whether the prerequisites of the self-defense were present. If, however, the evidence is insufficient to allow a reasonable doubt to be raised, no self-defense instruction is appropriate. In determining whether sufficient evidence of self-defense exists, all reasonable inferences should be resolved in favor of the defendant, and the testimony that favors the defendant and any other evidence must be treated as true. A judge need not instruct regarding self-defense unless the evidence raises a reasonable doubt as to each of the predicate components, in short form, those being a reasonable concern for personal safety, retreat or no avenue of escape, and no more force than reasonably necessary in the circumstances. What factually distinguishes this case from many, if not all, of the cases cited on both sides is the paucity of percipient witness testimony. That is, in the cases cited by the parties, the court was presented with evidence from either the defendant's testimony or the testimony of other percipient witnesses, often multiple witnesses, who both heard and observed the encounter, and the errors in those cases stem from the trial court's decision not to credit that testimony that was most helpful to the defendant. I cite Commonwealth versus Galvin, 56 Mass Appellate Courts, 698 at 701, a 2002 case, as an example of that. Here, the only percipient witness who testified is Sophia Ritchie. As I said, I've listened to the relevant portions of her testimony since our hearing yesterday. Her testimony is quite limited with regard to what she observed. In summary, she testified that she went right upstairs after school, that she made general auditory observations of her parents. That is, she heard loud voices and her mom yelling, although she could not hear the words. She also testified that she heard movement and banging downstairs, but that the totality of that wasn't alarming to her because it was the type of argument that she was used to. She said it was not too loud enough that she could hear the voices. She stayed in her room until her mother called her name. When she arrived in the kitchen thereafter, her mother was panicked and shaking, crying, and she observed her having difficulty breathing, so much so that she gave her medication. Crediting Sophia Ricci's testimony, along with the other limited evidence presented of the encounter between Michael Ricci Sr. and the defendant, namely the defendant's statements to the police of the encounter when they entered the home on 1/28/21, and the text exchange between the defendant and her son Angel, and viewing that evidence and any reasonable inferences therefrom in the light most favorable to the defendant, the evidence fails to raise a reasonable doubt as to any of the predicate components necessary for self-defense, namely, one, that the defendant reasonably and actually believed that she was, quote, in imminent danger of death or serious bodily injury from which she could save herself only by the use of deadly force. Two, that the defendant could not have avoided physical combat with Michael Ricci Sr. or was unable to retreat. That is, that she attempted to avoid further physical combat or that she was unable to do so. And three, that she used no more force than reasonably necessary in the circumstances. I cite Commonwealth versus Pike, 498 Mass, 395 at 398 to 399. Commonwealth versus Hart, 428 Mass, 614, 615, a 1999 case, and more recently, Commonwealth versus Wynn, 489 Mass, 242, 253, a 2022 case out of the SJC. The case I have reviewed and considered the defense's citations, in particular to Harris and Ortega, and I know in passing that the situation presented in Harris is quite different. There, the defendant testified, among other evidence, and the defendant testified directly to the fact that the victim had threatened to shoot him and that he heard the defendant say 3 times that he was going to shoot him. Also, he testified that the victim grabbed him by the throat, thereby rendering the defendant incapable of retreat. And that the defendant did not grab the knife until the alleged victim had him by the throat. I also reviewed Ortega, and in Ortega, as the SJC recited, there were numerous visual percipient witnesses who testified to the shooting. There was conflicting testimony, with some testifying in the light most favorable to the defendant, that each of the 3 predicate components for an instruction on self-defense, warranting instruction on self-defense, again, crediting the version most favorable to the defendant, were there, and that the case said that it should have gone to the jury, and under those facts, it should have. Those cases are readily distinguishable from the record before this court. In summary, to instruct the jury on self-defense would invite it to speculate on hypotheses not supported by the evidence, which is prohibited under our laws. And I'll finally cite to that proposition enunciated in Commonwealth versus Patton, P-A-T-O-N, 31 Mass Appellate Court, 460 at 463 to 465, a 1991 case. The lingering evidentiary issue that was raised by yesterday's proffer by the defendant of the Sweeney Dolly recovery single-page record. I want the parties to tell me, again, we had it on there yesterday, but I want it put on the record now, that because it's not on that piece of paper that the defense offers, the date of that the parties believe this Sweeney Dolly Recovery Center record is from. I know it's 1999, but what's the date? That's
1999, you mean 2019?
What's the date? I went looking for it on the actual document itself, but it's not on it.
It isn't on the document, Your Honor, and all I have based on what was summoned originally via Rule 17 was an authorization for release of treatment as the page before the page in question that was signed by presumably Michael Ricci on June 6, 2019. I think it's reasonable to infer that if this is the first page in the record, that this might be the first page of biographical information that was captured when he first began his treatment with this particular provider. So that would be my assumption. I don't know if it's a fair assumption, but I do recognize that these first few pages do not identify any particular date. There are subsequent records or dates within this record where you could tell that there was an office visit and the date is recorded, but there is significant confusion, especially in light of the fact that it does appear that each time the record might be printed from whatever database it's in, a different date is generated at various points within the record, which I think accounts for why his age appears to be different in each of the records, because the record before the court, I believe you mentioned that it said he was 54, which would be what he would be today if he were alive. In the record I have that was summoned back in 2022, it lists his age as 52. So,
But as far as and maybe I'm asking the wrong party, as far as the date of this document, Attorney Wood, what is the date of this document and how do you know that?
Don't have a precise date, but I do know that this is through inference from the other records, that it predates June of 2019. So very likely the first office visit was June 6, 2019 from the rest of the record. And presumably, and again, this is through inference, this intake and diagnosis sheet was created as part of his medical record when he was signing up with Sweeney Dolly, which suggests that it would have been either probably at the end of May 2019. And it would have extended the time where he was being seen by them would have extended to September, end of September 2019. Yes.
All right. In addition to what I raised yesterday with regard to the patient psychotherapist privilege, which I note, to adopt the defense's suggestion that the diagnosis was somehow not covered by the privilege would eviscerate the patient psychotherapist privilege in the way that, as the defendant proffers it, it would be impermissible and covered by the privilege that the statements that the decedent made in connection with his treatment by Sweeney Dolly Recovery Center personnel, but that the actual diagnosis was somehow not covered. So it would be the result of which would be the jury would be able to hear the diagnoses, bipolar and other summary diagnoses, but not the underlying communications relevant to that diagnosis. That's an initial matter, but not the reason I'm ruling on this. Doesn't make any sense to me for the reasons that I just stated. The document as presented, and I'll accept that it was the counsel's representation that it was the end of May 2019, sometime before the end of May, or around the end of May of 2019, that this information or document may have been generated. It is unclear to the court whether those diagnoses, even if they were not covered by the privilege, is a diagnosis of the provider here at Sweeney Dolly Recovery Center, or whether it is information that the decedent gave to a provider or administrative person of past diagnoses of his. Regardless of either of those, the confusion that lingers in this court's mind with regard to those, the offered evidence will not be admitted based on the lack of any temporal relevance to the events of 1/28/21, particularly in light of the fact that other more close in time records of the decedent do not or are inconsistent with the diagnoses. But the reason for I'm not allowing this, in addition to the reasons that I said yesterday, which I think are separate and independent, is that the relevance of this document, it is too remote in time to assist the jury in its fact finding. So let me let you first, let the defense first put on the record whatever you wish to with regard to the rulings that I've made so far this morning.
I'm objecting to the self-defense instruction not being given, as well as the Sweeney Dolly record not being introduced for the reasons stated yesterday. I would like also to say that if Your Honor is not inclined to allow it in, then there shouldn't be any argument from the Commonwealth with regard to Christine Ricci making up diagnoses as part of their story of control that they want to tell. I don't think that's appropriate. If I'm not allowed to put in a record which has what seems to be a medical diagnosis in it, and they're going to talk about control, and they're going to talk about Christine Ricci making up diagnoses, that puts me at a severe disadvantage. And I think if it's off the table, then it's off the table. We won't talk about whether it's a true statement or not that Christine Ricci made that they put in. But I don't want there to be, I don't think there should be, I don't think it would be fair to allow there to be argument on their side that this is a control issue, that this diagnosis is a control issue, that under these circumstances.
Good morning,
Yes.
Your Honor. With regard to that issue, the Commonwealth does not intend during its closing argument to speak about how the defendant may or may not have told people and peppered people with an idea that the alleged victim had mental illness. We're not planning on going there. However, we absolutely plan on talking about control as part of the events, including the fact that based on the evidence, it appears she was telling people he's an alcoholic, he has memory issues, but we will stay away from, as I think I indicated this yesterday, we're not, or at least I was thinking, we're not intending to go there in the closing argument. So I don't think that will be a problem.
All right. Let's turn to the remainder of the jury instructions, and in particular, well, I don't have any particular agenda. Where do you want to start?
Oh, Your Honor, one more thing about the medical record, just for the record.
Yes.
Since we gave you the redacted version, which didn't have all of the statements that we wanted from the medical record originally, because we thought that it fit your definition under McLaughlin about what was non-diagnostic and what the the attempt to distinguish, or the distinction that was being made between self-serving statements or hearsay statements versus statements of diagnosis. But also, we're not able to put in the statement from that record that does involve a statement of past physical abuse during a dissociative episode. And we also think that they shouldn't be able to argue that there never was, not in the Sweeney Dolly record only, but in the Pembroke record, which was part of that same motion. They shouldn't be able to argue affirmatively that there were no instances in which the decedent was violent with the defendant.
If I hear him correctly, he's referencing not in the Sweeney Dolly record, but a comment in a different record that isn't before the jury. Again, for the same reasons we argued that those statements shouldn't come in as hearsay, they shouldn't be offered, and it shouldn't preclude us from arguing what the actual evidence is before the jury. So I would argue that that is fair game based on the testimony before the jury, and that those statements don't negate that, because it doesn't identify any specific incident. There's nothing to corroborate that particular incident. And for all we know, we don't know the source of that information. We presume it's the decedent who's not here to tell us one way or another, but we don't know, and we can't speculate.
All right, I'm going to stick with my earlier rulings. I know the defendant's objection. Commonwealth may make that argument that defense is objecting to.
Could I just put the Carroll case 439 Mass 547 on the record?
Yes, I haven't looked at it, but yes, you may put it on the record. So in light of my rulings, and I'm just going to start turning the pages of the, were you able all to print out the instructions? I noticed, and I'm likely going to notice as I read through the instructions, I always pick up things. And because of the sort of the turnaround time for this, I noticed in the first paragraph, there's some missing words just before the done so in accordance. It should have said you have done so in accordance. I'm sure I'm going to pick up other little things like that as we go through. But the first change to the instructions as I drafted them to you, it seemed to me, is on page 6. The italicized language consistent with my ruling is out. The other italicized language there is there for a particular reason. As I was going through last night, the requested instructions, the defense asks for one of the instructions that the defense asked for was accidental. You asked for it actually, and I printed it out last night, but it's in my chambers right now. The instruction from either the BMC or the district court number, but the murder charge, homicide charge, has that built into it. And that is that language that I have there. I'm reticent, for lack of a better word, given the import of the SJC's model instruction, to start monkeying with it. And I'm inclined to give the instruction, the accidental instruction that's italicized there on page 6. It comes up, and we're going to see it again. But I'll give the defense the opportunity to convince me otherwise, and just make a record with regard to why, in your view, the model SJC instruction on accident is insufficient, if it is.
Well, the supplemental instruction has more definition and defines what an accident is, and therefore I think it does tell more. Also, we're not just dealing with a murder charge in this case, we're dealing with an assault and battery dangerous weapon charge, and this accident instruction would be instructive and gives more guidance than the embedded accident instruction within the model murder instruction. I think we're entitled to it, and I would ask that it be given.
All right, Kamal, anything on this?
Your Honor, I just ask that you include the instruction that's in the model and not the district court version. I think for purposes of this case, because these charges are brought together, there needs to be consistency in the instruction. And so I would ask that the court impose the SJC model.
I'm going to import the SJC language into the assault and battery charge so that it's consistent. I don't think I did that last night, but I will add that. And it, obviously italics is coming off. Let's talk about page 7, the mental impairment paragraph. That also is lifted, similar to what I was just talking about, not the district court, but it is the SJC's version of impairment. Thank you. I know the Commonwealth wanted some time to think about that. I saw that you passed through the clerk a case, which, just for the record, is Commonwealth versus Santiago at a 485 Mass 416 2020 case. Talks about when mental impairment is appropriate. I had the case very briefly summarized to me. I haven't even read it yet. I'll be frank with you. I've read pieces of it, but it seems to me that the difference there is that we were talking about a physical mental condition for which expert testimony would be necessary for the jury to make heads and tails of what that impairment would have to be. Here, there's evidence both that the defendant suffered from some conditions that required medication, some suffered, I'll call it, mental health issues, for lack of a more precise characteristic or description, that led her to self-harm. Seems to me it's distinguishable from the type of, there's no bright line, as I understand it, that expert testimony is required. And it seems to me, given that the nature is not a physical injury, but rather testimony I mentioned and other testimony that is supportive of mental health issues, that it's permissible for the jury to consider it at least.
So, in the limited research I could do last night on the issue, I was looking for some guidance in the case law as to what exactly mental impairment meant. And first and foremost, I agree with the court that the model instruction on impairment would be the appropriate one versus the one proposed by counsel, which did appear to be a district court instruction that uses very different language than the model. That's just a first point. But as far as what mental impairment actually means, I think that's kind of an amorphous concept at this point because there is no definition of mental impairment. But in what I could see in the case law, and Santiago was kind of one distinguishable example that I thought was different than the other cases I looked at, were that in all the cases that talk about mental impairment, it's usually in the context of a lesser, not absolute defense, but more a defense to mitigate essentially intent in the murder charges. And that those cases that distinguish the lack of criminal responsibility to mental impairment or offering mental impairment when criminal responsibility is not available, they all have to do with some sort of mental illness that is articulated in the evidence. And in this case, I'd suggest it's really not. There's some observations of particular behaviors, and certainly there's evidence before the court and the jury
Isn't
about
that argument though? If the instruction says you may consider any credible evidence that the defendant suffered from a mental impairment, you can argue that there is no credible evidence that she suffered from a mental impairment.
And I agree. And I think that argument is fair game for the defendant to argue. But I think instructing the jury about mental impairment draws unnecessary attention to something that isn't clear in the evidence. And so I think the instructions should be informative of information clear in the evidence to advise the jury of what they can consider and how they can consider particular pieces of evidence. I think it is fair argument for the defendant to argue that her mental state at the time of this particular incident, which there has been testimony about, does affect her ability to form specific intent. But to instruct the jury about mental impairment where there is no testimony either from specifically from the lay witnesses or from experts or from any records to say she actually suffered from something that could affect her capacity to evaluate her acts, like post-traumatic stress or some sort of underlying condition that might have affected why she was cutting herself, that it's not proper to instruct on that.
All right. Defense, you want in on this?
Well, I think it's a difficult thing because if I'm allowed to argue it and they don't know what to do with that argument, then that's a real problem. Now, it's sort of like the consciousness of guilt instruction on their side. There's very little evidence of consciousness of guilt, but I suggested that they should only be able to argue it. And they said, well, as long as there's any sort of ability to argue it, we should be able to get an instruction as to what they do with that information. And here, it seems like if I'm up there arguing and talking, just think about the evidence for 1 second. We have, through the Commonwealth's questioning of Sophia, that mother is on a multitude of medications. We have panic attacks, which have been elicited both from Sophia and others. We have a suicidal ideation that has been elicited through prior bad acts through potentially 3 separate witnesses. If we're not able, now, ultimately, that may not be credible, but that's not the question that's a question for instruction. It's a question for argument. And again, it has been raised, and it hasn't even necessarily been raised by me. It's been raised by them.
All right. It's staying in it, but the instruction you're getting is the one from the model jury instruction. And you can make your respective arguments with regard to whether the information that she suffered from a mental impairment is credible and whether it in any way impacted her ability to be intentional in her acts. On page 7 through page 11 will be removed to the top. The edit will be made to the 4th element of the first-degree murder charge. I think we agreed yesterday if self-defense was out in connection with the other, it's out with regard to the 3rd element at the bottom of page 11. On page 12, force coming out. on page 13, that italicized should stay in based on my rulings. Yes?
Yes.
And also the mental impairment stays in. On page 15, that italicized language is out, as is under second-degree murder, out. On page 19, 3 is out to the top of page 20. Same item 4 on page 20. '21, the italicized language is out. 22, the italicized language is in. When I was reading through these definitions, the supplemental instructions on the model instructions, I took out the one with regard to human. There's a discussion about a fetus. I don't know. I don't think it's relevant to this case. I also question whether or not the definition of death was relevant, but I'll leave it in there for the time being. The use of a dangerous weapon instruction, I note the defense's objection to that. I think it's appropriate in this case. I'm going to give it. This instructions, unlike some other instructions that I've used in the past, does not walk, and these instructions, which I'm talking about the model SJC jury instructions on homicide, does not do what I typically do in cases when there are lesser included offenses, which I go back and say to them, you know, if you can't find all the elements of A, B, C, and D, then you must next decide whether the lesser included offense of blah, blah, blah. That's not how this is worded. If that was worded, I think the defense's objection to it being repeated as a separate instruction under the jury's obligation of innocence and guilt might have more traction with me, but it isn't set out that way. So I think it's appropriate for the jury to hear at one point that it is both their obligation to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt, and at the same time, the second sentence, which says, if they didn't prove anything beyond a reasonable doubt, you must find her not guilty of all the charges. So I think it's pretty balanced and it ought to be given. Moving on to the assault and battery with a dangerous weapon. The two theories, one being intentional assault and battery, the second being reckless assault and battery. I put the self-defense at the bottom, and I'm taking it out based on my rulings earlier. If they're still standing at that, they're seated at that time, I'll have them stand up, shake it out. We'll see what time it is in terms of, you know, whether we're going to take a break. If you're in need of a break at that point, I don't know how long it's going to take. It's a while. Just cue me, let me know so you're comfortable when you start your work. Oh, let me not go hot. I went a little too fast. Want to add in the, what did I just say I was going to add in from the homicide instruction into the A and B, right? Hold on.
Yeah.
Thank you. Okay. So it seems to me that that should be added. after the third element on intent, right? Agreed. It'll be between the third and fourth element. I'll add it on both of intentional and reckless. That same instruction. All right, then we get to the second half of the instructions. I added an instruction. I think it was getting late, by the way, so if I missed something, please let me know what I missed. But I intended to put in all the instructions that either side asked for. We, on page 40, I need your assistance with what the exhibit numbers are so that I can tell them that has the redacted evidence. So maybe when I'm working on the revisions, you can work on that and give me what the numbers are when I go back to work on these revisions.
We did kind of raise it with Madam Clerk just to flag what we actually had to replace.
Okay.
So I do have the
Oh,
numbers.
that'd be great. Thanks.
Exhibit number 14
Yes.
is the redacted scene video. Exhibit number 56 is the death certificate.
Uh-huh.
And exhibit number 57 are South Shore Hospital records.
What about the redaction from the text? I remember that one because they were the ugly white redactions. I don't mean that as any.
It's okay.
They were.
They
We
are.
can all
I
agree they're
agree.
ugly white redactions.
That's numbers 32, 33, and 34.
All right. If anybody has any more additional ones to add to that, I'm happy to do that. I highlighted on page 41 my attempt at 10 o'clock last night or whenever I sent this to you to summarize just generally what the prior bad acts evidence is. But I wanted to bring your attention to it, which is why I italicized it and I underlined it. I'm willing to hear other ways that I can phrase that. If you wish, just let me know what you're asking me for. And you know what, I am gonna be stepping off the bench to do the edits. So you can give them to me now, or I'll give you a few minutes because I know that you got these late and may not have focused on that.
My only comment with regard to the categories that are laid out is taking out the word punching and putting the word hitting.
Perfectly fine.
Without punching, put in hitting.
Hitting instead of punching. Again, I will obviously remove the bolding and underline. That was just for you, so that would draw your attention to it. There's some spacing issues. Impeachment by prior inconsistent statements. I thought I heard it. Did you want it in there or not?
I didn't, but Your Honor, before we get there, can we talk about consciousness of guilt?
We can.
Okay. So obviously object for the record based on yesterday's argument, but also we have some proposed language from which we took from the Nyland case. It's a general proposition of law, and obviously Nyland was decided sort of on other, well, in part on other grounds, but this is what we would like to add. After the words, "You are not required to draw such inferences, and you should do so, and you should not do so unless they appear to be reasonable in light of all the circumstances of this case," we're asking for the next line to read, "As to indictment 1, any potential inferences regarding consciousness of guilt may be probative only as to whether an unlawful killing was committed and not relevant whatsoever to the question of malice," which is a statement of law that goes back, but the Nyland case quotes the Commonwealth versus Law, which is a 1984 case at 391 Mass 97.
Now, let me get that again. As to indictment 001, any potential inference regarding consciousness of guilt may be probative only as to whether
An unlawful killing was committed and is not relevant to the question of malice. Is not relevant whatsoever to the question of malice. That's the quote from what we drafted it based on that.
Just give it to me one more, Pat, maybe probative only as to whether the unlawful killing was committed and is not relevant to the issue of malice, is it say?
Question of malice.
Question of malice.
Not relevant whatsoever to the question of malice.
Is the Commonwealth objecting to that further clarification?
We would just ask that you stick with the model instruction. What's quoted in your instruction and what the Commonwealth proposed was from the latest 2018 model SGC version of consciousness of guilt. So I would ask that it be the standard instruction.
All right, I'm gonna give it to him.
You're gonna give it?
Yep. Nobody wants impeachment by prior inconsistent statements. Out. All right. It should be search warrant, not warrants, or were there warrants? They're warrants. We'll leave it as multiple. What? Did I miss any of the instructions that you wanted, recognizing that the embedded instructions with regard to mental impairment and accident are, we've discussed those.
So I know that this goes beyond the SJC model instruction. I know the court's position so far about this, but there is a second part to the graphic photographs instruction and the district court model instruction that I think applies to this case. And this is testimony or evidence that may evoke an emotional response. And what it reads is, sometimes evidence is presented that may produce an emotional response. For example, it's natural and understandable to feel sympathy and empathy when you see or hear about a person who was allegedly injured in a serious way or who suffered in some way. I instruct you that you must separate any emotional response from the value of and weight of the evidence. You must find the facts in this case based solely on the evidence and not on your emotional response to the evidence. You must not base your decision on sympathy, anger, passion, prejudice, or pity. Rather, your verdict must be based solely on the evidence, in this case, in my instructions on the law.
Any objection to that additional instruction?
Well, I think it's repetitive because Your Honor gives that at other points in the instruction, and there is reference to.
Where's the emotional? Can somebody? Well,
Hand it up.
you can hand it up. What I'm going to do is when I get back there, I'm going to look at the other instruction that I've given on emotional testimony. I will say that well, I'll look at what else is out there in the instructions on emotional testimony. I may add in some additional language that's not repetitive of what's in the graphic photos. I won't put it as a separate, I'll put it as embedded in that instruction. If I think it's appropriate that it's not covered, that emotional component is not covered elsewhere.
Understood. Can I pass it up?
Yes. All right.
Okay, pause. Holy macaroni. Hi, RA Raid. The number of people watching is glitching my StreamYard. And I can't do much. But Recovery Addict, if you're here, thank you. I've been on rewatch the whole week, and I cannot imagine how exhausted Recovery Addict must be from having 3,000-ish people in the chat and trying to keep up. Wild. Okay, so here's what we're going to do. We're going to have to... oh, Lilith, you reminded me. Thank you for gifting the membership. I just remembered something. We're going to need to do a recap. So, here's what we're going to do. We're going to go here. We'll come back to Judge Boyd. The TLDR is he didn't show. That's it. Okay, so we're going to do a quick recap. I just have to hope that they don't cut the stream for whatever reason. I'm going to do the defenses no, this is what we're going to do. We're going to do this one, and we're going to just skip past. Just wait. No. 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 Change our mind. Change my mind. This tab is what we're going to do. Where are we? We're here. And this is going to be defense's opening. What we know so far outside of this, the defense has rested. The point we're at now is essentially the judge is going through the instructions. The summary of the entire story, just like the bare bones, is in the description. Essentially, Christine Ricci is charged with killing her veteran / firefighter husband, who allegedly struggled with alcohol problems, potentially bipolar, and was coming at her and fell on the knife, or there was a struggle with the knife. I can't put cat cam on right now because Frank is busy cleaning his Frank. Okay, wait, there you go. So that's kind of where we're at this point. State has rested. The judge has just taken out self-defense. She's not giving them self-defense. She's not giving the expert to say that he had bipolar. Defense isn't done yet. Defense isn't done. Only Commonwealth is done. I think I said that wrong. So defense is starting today. Commonwealth has managed to win all of the objections in the jury instructions. There is absolutely zero self-defense allowed in there. They can't use the psychologist that he was seeing because she is away on holiday and they can't verify the documents. That's quite a long thing. I explained it at the end of yesterday's stream, but we're going to quickly watch the opening of defense because there's been some scandal with the media. First of all, things just keep disappearing from the stream. So if we don't catch it live, then we have to just wait and see if it comes back. Second of all, judge kicked the cameras out yesterday. That's why I'm trying to talk super fast and get back.
Intended to kill Michael Ricci on January 28, 2021. And the Commonwealth doesn't have any evidence to prove that she did. The argument that occurred that was just described to you, the confrontation that was just described to you, all of that information all happened during about a 15.
Okay, sorry, I just saw a bunch of things saying I need to introduce myself. Hi, I'm Vicky and I'm an addict. I was gonna say that's not true, but it is true. I'm in recovery. And the joke at one stage was that I was gonna start a channel called Recovered Addict. So I am a journalist. I'm in Cape Town, South Africa. And what else do you need to know? We don't have juries. I sometimes get a little frustrated with the juries. Generally, I disagree with a lot of the way that the media presents things in the US compared to here. And I try to stay objective, but sometimes you might hear my opinion if I'm tired. That cat is Frank. The fluffy one is Winchester. The skinny one that tries to breathe my breath is Phoebe. And Phoebe is after Phoebe Buffet, Friends, my favorite show. And Frank is Phoebe's sister in Friends. Winchester, we found her outside Winchester Hotel. Okay. Let's go.
Small 15-minute pocket between 4:30 and 4:45 on January 28th, 2021. And every answer to every question that we have about Christine's intent, Michael's intent, Michael's last actions and Christine's actions are contained and sealed in that 15-minute pocket. And ladies and gentlemen,
That's probably why the Commonwealth is going to spend such a small amount of time talking about that 15-minute period, because they want to distract you. Christine's words are really the only evidence that we have of what occurred during that 15-minute pocket. And those words, remember, were spoken in the moments after all of these events happened. It's true that she doesn't give a complete statement of everything that occurs. And as we go through the evidence in this case, and when I come back and talk to you at the end, I'm going to suggest to you, through reference to both the forensic evidence as well as putting together the statements, about what probably happened around and between the details of what it was that she said. When the police arrive, the evidence is going to be that Christine Ricci is absolutely beside herself. Absolutely beside herself. She is crying, she is heaving, she is hyperventilating. The first responders come to the scene and she can get almost nothing out. She says he collapsed, that comes out. The Commonwealth wants it to be the case that that means that she told some sort of misleading statement. The evidence is going to show that she gave an incomplete statement and that maybe she wasn't in a position where she even could give a complete statement. She was just too upset. After Michael Ricci's body is removed from the house out to the ambulance, there's going to be evidence from an officer by the name of Chris Martin, who's going to say that at that point they sat her in a chair and they asked her what happened. While the body is still out at the ambulance, while they're so-called discovering the stab wound that you just heard a moment ago. And the evidence is going to say that when she's confronted at that moment about what happened, she gives a little bit more detail, but she's still extremely upset. She's so upset, in fact, that she actually takes some medication to try to calm her down. But as she begins to say the details of the case, she mentions the knife, and she mentions the argument and the fact that it escalated. And that's going to be supported by the testimony of Sophia Ricci, who heard that escalation of the argument into a screaming match. And it's true, she does say, I held the knife out. And then at another point, she does say, he lunged at me. And at another point mentions being attacked. And I'm going to suggest to you that the evidence will be that even when Christine said those words, that wasn't everything that happened. And at that point, the evidence will show she may not have had a complete memory of what had just fully occurred. But Christine Ricci's words are the only direct evidence that you're going to have about what happened between 4:30 and 4:45 p.m. on January 28th, 2021. They're the only eyewitness reports of what happened. And they don't at all support the story that the government just told you. And that is probably why they are going to spend the entire case discussing things that didn't occur during that period of time. I expect that they are going to parade a bunch of witnesses in, remote friends of Michael Sr., who are going to be allowed to offer their opinions about the defendant, that they are going to pick along a 2.5-year period, a series of isolated events, and try to string them together to create the most damning possible picture of who Christine Ricci is. And that they will do so because they hope that you will be so distracted by the question of whether Christine Ricci is the type of person that would commit this crime, that you'll forget that the real question is whether she actually did it. As I say, at the end of this case, we will hear forensic evidence. We will come back and we will tell you a little bit more about what happened in January 28, 2021 in the absolutely critical 15-minute period. Talk about the mechanics and what's suggested. And a lot of it will be inference by inference, because we won't have that type of eyewitness testimony beyond someone's statements that was very, very affected by what had just happened to them. But what emerges from that is a very, very different picture altogether. Now, the Commonwealth wants you to tell you these stories about the past and about the affair. And it's true, there's going to be a story about an affair, and it's going to be a big part of the Commonwealth's case. This was an affair that took place in 2018. And a lot of the events that they're going to talk to you about physical confrontations, happened within just a couple of months of that event, maybe anywhere from a 6-month to 9-month period after that event. You're going to hear about other events that happened in the subsequent year and a half. Things like Michael going to AA, Christine supporting him and going to AA, him getting sober, him getting counseling, Ms. Ricci getting separate counseling, them going to couples counseling, them reaffirming their vows in Hawaii in 2019. And you're going to hear from all of the children, and although they're going to say that there was fighting still and there was a fair amount of marital discord, they're not going to describe the type of events that were occurring in 2018. But the Commonwealth wants to sort of string these things together from 2.5 years earlier to try to pretend that that says something about Christine Ricci in 2021. I'm going to ask you not to be distracted, to focus like a laser on the relevant period of 4:30 to 4:45 on January 28th, 2021. And I want you to be extra vigilant every single time the Commonwealth tries to distract you and talk to you about ancient history and tries to tell you about who Christine is and why you should believe bad things about her, and focus on what do they actually know about what happened on January 28th, 2021 between the hours of 4:30 and 4:45. And if at the end of the day, what you're left with is, I just don't know what happened, which is exactly where they are, then I'm going to ask you to find Ms. Ricci at the end of this case during closing, not guilty.
I really like this defense attorney. If you look, I think I left it as the pinned comment. I've got a recap. It's not my videos. It's different channels' videos, but it's just the shortened, the clipped versions. This is a really good case so far, though, very interesting. We have looked at what the jury instructions say, and so far it does look like she is, as it stands, without the defense having put on their case, it does seem like it is. She's guilty, unfortunately. I don't feel like she should be, but yeah, Lilith's got the right time. The other thing is 1 month. Feels like I've known you guys forever. That is, it's so cute. Like, YouTube did this little animation thing because I got 100 members, and I was like, oh, I feel like I'm gonna cry. Okay, this is the point where I say it's time to focus. We're gonna hop back to the live. And if they've started, we're gonna skip the jury instructions. And we're gonna go right in because I need to get into focus mode. The other thing is we're called the Macaronis because we couldn't have Mac members because I might be sued. My name is Vicky McCallum, in case you missed it when you're raiding. Please be kind to my mods. This channel goes between like 7 to 20 people on most days. So this is a lot. Bug. Thank you. Thank you. Thank you. And we do freaking love pasta. We really love pasta. I've been eating pasta for like Greeners, aka Adam. If you don't behave, I'm gonna unchannel management you. Also, it does really help the channel if you like the video, subscribe. Chatting helps the most. So chat as much rubbish as you want to. I don't mind. Psychosaurus, I can't tag you because StreamYard is being weird. YouTube's being weird. Before I go focus, the question we had yesterday was that he was, his psychologist diagnosed him with bipolar. Psychologist is away on vacation, can't verify the documents, did give an affidavit. Judge didn't feel it was reliable. One of the things she cited was that Christine said that Mike was manic, and that's different to bipolar. And so, sorry, hiccups. Lisa! Guys, You make my heart swell. That's 15 gifted memberships in like a few minutes. You're so wonderful. Thank you. I can't remember what I was saying. Oh, yes. So defense argues you can be manic. Manic can fall under bipolar, could be a manic episode. State argues that she doesn't even know the diagnosis. She can't be bringing it in. Judge this morning said, without the experts, not happening. Right, let's go. We're ready. No, last thing. The audio is absolutely terrible. I'm sorry. It is boosted on my side. Just a warning. Here we go. At least one manic episode is required for a diagnosis of bipolar. So then that works, you see. That's what they were saying. She was saying at the point that he came at her, he was in a manic episode. Jen, we've missed you. You've not been around much. Okay, guys, seriously, I need to be writing. So we need to get cracking here.
Can you please stand and raise your right hand? Thank you. Do you solemnly swear that you will give true answers to such questions as shall be put to you in this matter now and here before the court, so help you God? Thank you.
You may be seated, ma'am.
Your Honor,
Yeah.
I just inquire, should this process be on camera?
Well, it's part of the trial, and it is, I don't know that there's any basis for me excluding the press from this. Good morning, Ms. Ricci. As you know, my name is Diane Frenier. I'm the judge presiding over this case. One important decision that all defendants in every case need to make is whether or not they wish to testify. You have an absolute right to testify at this trial, and your right whether or not to testify is solely your decision. This means that you're not required to take your attorney's advice. I am sure that your attorneys, Attorney Wood, Attorney Barry, have told you that if you do testify, the Commonwealth has the right to cross-examine you. That is the right to ask you questions. If you do not testify and your attorneys request it, and they have so requested in this case, during my final instructions to the jury on the law of this case, I will tell the jury that you, like all persons charged with a crime, have the right not to testify, and that the jurors may not speculate about your decision not to testify. Ma'am, have you discussed with your attorneys the decision about whether or not you wish to testify at this trial?
I have.
And have you had enough time to discuss with this question or this decision with your attorneys?
Yes, I have.
Has your attorneys discussed with you the pros and cons of testifying and not testifying?
Yes, I have.
Do you understand what your attorneys have explained to you about your right to testify?
Yes.
Has anyone made any threats or promises to you to get you to give up your right to testify on your own behalf?
No.
And have you made a decision about whether you will testify at this trial?
Yes.
And what is your decision?
I will not.
Ma'am, in the last 24 hours, have you consumed any alcohol or alcoholic beverages?
No.
Have you taken any drugs, legal or illegal?
Yes.
And were those drugs limited to prescription medications that you take in the normal course?
Yes.
And did you take those in the normal amount?
No.
You didn't take them in the normal amount?
No.
You making some? All right. So is it fair to say that you haven't been getting at the exact same times that you would normally get them?
Or the doses.
Okay. Is your mind clear here today?
Yes.
Do you have any concerns about the clarity of your mind in connection with this decision not to testify?
Yes.
You do have concerns?
Oh, no, I'm sorry. No.
Do you have any concerns about the clarity of your mind with regard to your decision not to testify in this case?
No.
Anything else that the Commonwealth wishes that I inquire of?
I don't believe so.
Anything else that the defense wishes me to inquire?
No, Your Honor.
I will say that I made observations of the defendant throughout the trial from the beginning of jury impanelment to this moment. She seems engaged with her attorneys, as frequently as is appropriate, consulting with her attorneys about the case. And those observations are consistent with this finding, that I find that the defendant is freely, voluntarily, knowingly, and intelligently waiving her right to testify in this trial. And she's done so with the knowledge of the consequences of that decision. So I'm going to go back and make the changes. I expect that I'll explain to them that we move on to the defense case, that you have no burden, that you'll stand up in line of what you've told me, that the defense will rest.
Yes.
We'll come over to the side of the bench for the renewed motions that I am anticipating, and then we'll get off into the instructions. Does anyone need anything in terms of the layout of the courtroom for your closing arguments? And if so, just make it known to the court officer, and we'll accommodate that in between this break.
Just asking, while your honor steps off to make those revisions, are we permitted to mark for ID some of the items we discussed yesterday, as well as do the redactions so that that's done, or would you prefer us to wait until the conclusion of the instructions?
Just, why don't we do it right when I step back on you can do all the prep work, get them all marked, but we'll just put it on the record when I step back on the bench. All right.
Thank you.
Court, all rise.
Okay, while court is in recess, I am going to hop over to, let's just get this thing quick. I'm going to just go through the recap. I will do a guilty or not guilty poll, but I'll do that after the closings. Just looking for this playlist quick. All right, so I'm going to start sort. Really? Won't let me sort. Sort. Date added oldest. Date published oldest. Okay, we've watched that one. We've watched that one. We're going to go to the 911 call, but I need to warn you first. You should probably put your volume down a little because I've got it boosted for the one that was so bad. Okay. Oh, that was a cat, but he moved. I'll go find some in a minute. Just want to see quick if they're coming back. Okay, are you ready to turn your volume down? Buddy.
Were you able to speak to him when he was on the phone? Did you see any, what if any injuries did you see?
No, I didn't see anything.
Did you see anything in your father's hands as he lay there?
No.
Where was your mom in relationship to where your father was laying on the ground?
She was right next to him.
Was there anything in her hands?
No.
And when you got downstairs, did you have a conversation with your mom about why your father was on the ground?
No.
Did she tell you aside from a conversation, did she make any statements to you about why he was on the ground?
No.
And what was the very next thing that happened?
She told me to call 911.
And did you do that?
Yes, I did.
And what phone did you use?
I used my phone.
It's like a cell phone?
Yes.
Okay. And how did you even know what to tell 911?
Can you explain that question?
I'll rephrase it. So at that point, you picked up your cell phone. Was it on your person? Do you remember, or did you have to go find it?
I walked down with it.
Okay. And with Her Honor's permission, may we just very briefly approach?
Yes.
Thank you. This time I'd ask that the disc of the 911 call be marked as an exhibit and played for the jury.
Any objection to that?
No, Your Honor.
Be marked and admitted as Exhibit 3, and it may be played.
Thank you. Exhibit 3 somewhere.
911, time to go with the emergency.
My dad is injured on the ground. I don't know what's happened, but he said it was something.
Okay, where are you located?
679 Lorraine Street.
Say it again?
679 Lorraine Street.
679 Lorraine Street?
Yes.
Okay, is he breathing?
Is he breathing, Mom? He's breathing.
Okay, stay on the line for me. I'm going to check through the vehicle, all right?
Okay.
Fire rescue, where's the emergency?
My dad is on the floor and he's breathing and he picked it up. And can you just please get the ambulance?
What's your address?
679 Lorraine Street.
679 Lorraine Street. How old are you?
16.
Okay, how old is your dad?
My dad is 50.
50. You said he fell?
Yeah, he's on the ground unconscious right now.
Is he breathing?
I don't know if he's breathing, but can you just please send an ambulance?
Okay, stay on the line. I'm going to get them started your way, okay?
Okay, he's breathing, but can you just please come here?
S3, C2, 7 Street. Look at that, 8-year-old male. Okay. 679 Range Street. Hello, you still there? Hello, you still there? You with your dad right now?
Yeah, my mom called in.
Did he fall or did he just pass out all of a sudden?
I don't know, I'm just getting down to the little man could fall asleep.
Okay, and he's not alert, he's not talking?
No, he's completely.
Okay, and he's not breathing normally?
No.
Okay. Do you know CPR?
I don't know that.
Okay, he's on the floor though right now? He's not on his bed or anything? Okay, you said your mom's there? Can I talk to her?
No, she can't, she's talking now.
Okay, because they're on the way, but I can give you instructions for CPR to help them, okay? They're on their way, but I can give you instructions to help them, okay? Martha Clark, Partners Traffic, entrance 3, traffic 679 Ryan Street, medical, so under 15. Is he on his back?
Yeah, no, he's on his side.
Okay. Can you have your mom roll him onto his side?
He's going on his side.
Or on his back?
No, oh yeah. Mom, roll him on his back. On his back.
Is he on his back now?
Yeah, he's on his back.
Your mom, they're on their way. I'm gonna give you instructions to start CPR, okay? Okay. Are you with me?
Yes, and my mom said to get her phone.
So where'd your mom go?
My mom said to get her phone.
Are you with your mom right now?
No, she's downstairs, but my dad had a lot of issues, and I don't know what happened, but all I know was screaming.
Okay. What are you upstairs getting for your mom right now?
My mom said to get her phone.
Her phone, okay. When you get back down there, is there a way I can talk to her?
I don't know. She didn't make it.
Dispatching and agree to 679 Rain Street, medical, so 1545. Can I talk to your mother, please?
It's kind of hard for a lot of us to do stuff. So when he come back from work or whatever, he do what he can.
Now, kind of jumping forward for a moment to the weeks prior to your dad's death, did you notice changes in his demeanor at that time?
Yeah. Thank you.
What did you notice about your dad's demeanor?
He was the same way kind of too, but like he was isolated before all the arguments and stuff. But it kind of seemed like he was trying to really either deal with what was going on or try to fix it. I saw like a lot of separation going on during the time, but then when they were together, it was either like very rarely it would have been like towards the end would have been the bonding experience was very like limited over the fighting, if that makes sense. So like the arguments would just overtakes what the good memory would have been if the argument wasn't in place, if that makes sense.
And is that something you observed between your parents?
Yeah.
Now, how about your relationship with your dad? Did you see some changes with your relationship with your dad in the few weeks?
Until he got sober.
What do you mean until he got sober?
Once he started getting sober is when I was able to like. My whole life I had a fear of my dad. So.
And did that change when he got sober? Is that a yes? You just have to answer out loud.
Yeah, sorry.
That's okay. And so did you find yourself coming closer with him at that time when he was sober?
Yeah, we were talking more.
Now, in the weeks prior to his death, did you still hear and see fighting in the household?
Following up?
Yeah, leading up to.
Yeah.
And did you see kind of your father either after a fight happened or kind of in the midst of one, what he would do during those fights?
Smoke.
And where would he do that?
Side door. So if there's only 2 doors we enter from the house, front door, side door.
Okay, but would it be inside or outside the house?
Outside.
And so where would your mom be when he would be outside smoking a cigarette?
If she wasn't out there with him, in the house somewhere. I mean, mostly in her room, just trying to stay away from it, you know?
When you would hear, excuse me, the fighting between your mom and dad, could you hear what they were fighting about?
I mean, like when I would have to, like at just like a passing ear, and it'd just be like the same record, like same broken record type of situation. Just a whole lot of just trying to figure things out. It's what it sounded like, you know.
And when you say trying to figure things out, was there any particular thing that your parents were trying to figure?
The affair.
You mentioned your dad getting sober. Do you remember when that happened, that he stopped drinking?
I know he had his 1-year chip, I believe. Possibly 2 years, I'm not sure.
Okay. When he would drink, what would he drink?
I mean, depends, but majority probably would be Bud Light.
And what were your observations of him when he would be drinking?
They don't want to be messed with.
Okay. So does that mean he would be by himself?
Majority of the times. Yeah.
Okay. And would he do it in the house or someplace else?
Inside the house, and if he had to go outside, there'd be some stash somewhere for him to drink on. So,
did you see a change in his interaction with the family when he became sober?
Yeah. He was like a lot more open, it felt like, or seemed like. But like, it seemed like his anger wasn't as bad as before.
At any point, Angel, did you see these arguments with your mom and dad, or hear the arguments with your mom and dad become more than just a verbal yelling back and forth?
Like through any of them, or just like, what do you?
Well, from the period of time from 2018, after your family learned about the affair, till up until the time of his death in January of 2021, did you ever see anything physical between the two of them?
Restate my objection, Your Honor.
I get your objection for the record.
Can I still answer?
Yeah, just a yes or no.
Could you repeat the question?
Between 2018, after the family was aware of the affair, up until January of 2021, when your father passed away, did you see any physical interactions between the two of them?
I don't think so. Not in that time period. Maybe beforehand, but.
If we may approach sidebar briefly.
Yes.
Give you mid-trial instructions, and this is the first time that I'm doing.
Experience was very like limited over the fighting, if that makes sense. So like the arguments were just overtakes what the good memory would have been if the argument wasn't in place, if that makes sense.
And is that something you observed between your parents?
Yeah.
Now, how about your relationship with your dad? Did you see some changes with your relationship with your dad in the few weeks?
Until he got sober.
What do you mean until he got sober?
Once he started getting sober is when I was able to like, my whole life I had a fear of my dad. So.
And did that change when he got sober? Is that a yes? You just have to answer out loud.
Yeah, sorry.
That's okay. And so did you find yourself, I have on the screen now what's been marked as exhibit number 9 that you've identified as a photo of a drawer in the kitchen, correct?
Correct.
Is that how you observed the drawer when you documented the scene?
Yes.
And why did the drawer stick out to you as something to document in this scenario?
Again, we're looking at knives in the area. It's just, again, I'm not sure what to call it. It's just a holder in the drawer that contained utensils, including knives.
So after you documented it as you saw it walking into the kitchen, did you do anything else to further identify what was inside of that drawer?
I'm sorry?
After you photographed the drawer itself as you saw it walking into the kitchen, did you do anything to the drawer to further identify what was inside the drawer?
I mean, I would have looked in the drawer and looked at the knives and just examined them.
And so in order to look in the drawer, what do you have to do?
Open it up.
Okay. And do you recall if you photographed the inside of the drawer?
I believe I did, yes.
May I approach the witness?
You may.
Let's just show you a photo.
Yep.
Is that familiar to you?
Yes, it is.
And what do you know that photograph to depict?
That's the inside when the drawer is fully opened.
I'll move to a witness's exhibit.
See which one it is? No objection.
The fully open drawer photograph will be marked as Exhibit 10.
And Trooper now showing you on the screen what's been marked as exhibit number 10, the drawer that you've identified that you opened. When you opened the drawer, did anything stick out to you inside of the drawer based on your response to the home on this particular night?
Yes.
What stood out to you?
There was some missing spots where some of the knives would have been stored.
Okay, and towards the rear of that drawer, it's a little hard to see. Was there something towards the rear of the drawer that caught your attention? If you need to stand up with the court's permission.
Yes, and you can also give him the actual photo if he needs to look at that, because it's pretty dark on the screen.
It appears that there's a knife that's out of place in there.
And so did that
Objection as to out of place.
All right, can you describe what you mean by out of place?
Yeah, so it appears that there's a knife. It's just kind of on top. It's not in a set position. It's not in the butcher block. It's not on an area where the utensils are held. It's just sitting on top of everything.
Move to strike areas where utensils are held. He doesn't have a basis of knowledge about how they keep their drawers, Your Honor.
All right, I think the jurors can divine their own conclusions with regard to the picture that's before them. I'll strike that last photo. Not the photo, the last testimony.
Trooper, when you made observation of that item at the rear of the drawer, did you do anything with that particular item to further document the item itself?
I would have taken just close-up photos of the knife.
Okay. Is there any circumstance where you would have to manipulate the item in order to get a better view of it?
If I couldn't get a photograph, if I was trying to photo it, I would have to, if it was, maybe tucked underneath there and it wasn't able to be photographed, I would have had to move it.
Okay. May I approach again?
Yes.
Show you another photograph. And is that photograph familiar to you?
Yes, it is.
And what do you know that photograph to depict?
That is, again, the knife moved in such a manner where I could get a good photograph of it.
And so did you yourself move the knife to photograph it?
I believe I did, yes.
I would object based on what we talked about before, but now also relevance.
All right. I note your objection. I overrule it. The photo of the close-up of the item will be marked as Exhibit 11.
Here. Officer, anything before this office of justice. I am feminine. Justice of the Superior Court, now sitting in the Commonwealth. Draw near, give your attendance, you shall be heard. God send the Commonwealth of Massachusetts. This honorable court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Good morning, May.
Good morning, everyone.
Good morning.
Before the court is the continuation of the jury trial matter. Commonwealth versus Christine Ricci. Ms. Ricci is present as represented by attorneys Joshua Wood and Laura Barry. The Commonwealth is represented by Assistant District Attorneys Jeremy Kuzman, Shannon Buckingham, and Jason Moran.
Good morning, jurors.
Good morning.
Jurors will start today with your answer to my 3 questions. Jurors, were you able to comply with my order that you not speak to anyone about this case?
Yes.
And were you able to abide by my order that you not do any research about the case?
Yes.
Did you all still have open minds?
Yes.
With those affirmations, we are ready to start today's work. As you know, the close of yesterday, the Commonwealth closed its evidence in the case. As you also know, the defense has no burden in the case. All the burden rests with the Commonwealth of Massachusetts to prove its case beyond a reasonable doubt. The defense does get the opportunity, if she wishes, to put on a defense. Attorney Wood.
Defense rests.
Okay. I'll see counsel decide on the bar. So with that, jurors, the defense rests. That means that you've heard all the evidence you're going to hear in this case, and we're going to move on to the important last 2 parts of this trial.
Those last two parts comprise my instruction to you. Sometimes I call it the charge to you. It's the formal description for it. And then the attorney's closing arguments. Just to give you some time frame, the charge is long. You're going to get it orally, and then I will give it to you also in writing so that you can use it when you deliberate the case. If at any point you feel that you're losing your attention and you need me to give you a break, you let me know. The closing arguments are also quite involved and they'll take some time. At any point, hopefully not during the closing arguments, but before you know those closing arguments are going to start, if you need a break, again, let me know. What's paramount to everybody in this courtroom is that you're able to keep your attention on what I'm saying and what the attorneys are saying at a later point today. I want to thank you for your jury service on this case. Jury service is an important part of our democratic self-government. You're responsible for upholding the law and our principles of justice. That's what you promised to do at the beginning of the trial when you took your oath as jurors. I want to thank you for your time, your attention, and your patience throughout the trial. You've all devoted a substantial amount of time to this case, time away from your personal lives, your studies, your work, your families, to sit as jurors in this case and to decide the very important matter now at issue between the Commonwealth and the defendant, Christine Ricci. You have done so in accordance with the finest traditions and the highest aspirations of our system of justice, and I thank each of you for your service and your sacrifice. You must now carefully consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt that Ms. Ricci is guilty of the crimes charged in this case. As I said, the final steps in this trial will take place in 3 different steps. First, I am going to give you the instructions now about the law that is specific to the charges in this case. After I do that, the attorneys will make their closing arguments, where they will highlight the evidence that they think is important and will argue in favor of the conclusions they ask you to reach. The defense will argue first, and the prosecution will argue last. After the closing arguments, I will give you more generalized instructions and will help guide you through your evaluation of the evidence and your decision-making and deliberations in this case. You will then work together to reach a verdict. Please pay careful attention to my instructions. All of my instructions are important, and you must follow all of them, even if you do not agree with them. To make sure that I give these instructions accurately, as you know, I am largely reading these instructions. That's deliberate. You will also get a written copy to refer to in the jury room during your deliberations. Due to the length of the charge, I'll be sending in a copy for each of you to use while you deliberate the case. I'm going to do my best to make sure that the instructions that I give you now orally match with those written instructions. If there is anything different between what I say aloud and what is in the written instructions, please follow my oral instructions now. Let me start with the prosecution's burden of proof and the presumption of innocence. There is a fundamental rule that applies in every criminal case, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Ricci is presumed innocent of the charges in this case. That means you must consider Ms. Ricci to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at the trial that Ms. Ricci committed the crimes charged. And I will explain.
That you moved to photograph.
Correct, yes.
Going back to the dining room area, Did you do anything to identify any particular items in the dining room area that were of interest to this particular case?
Yes, I did.
What did you do?
There was I don't recall exactly what was written on it, but there was a box of additional knives in the dining room area.
And when a particular item is noted and chosen to kind of for the potential for further examination, do you, as a crime scene services tech, do something to mark it or identify the area?
I do.
What do you do?
We put down what's called a placard. It's just basically just a piece of plastic. It has a number on it that's used to identify what piece of evidence that is.
And in this particular circumstance, when you were at Moraine Street on January 28th, was there a placard enumerated by placard number 1?
Yes, there was a placard 1.
And what item was documented at placard number 1, if you recall?
The placard number 1 was the knife on the floor there.
May I approach?
You may.
Showing you another photograph.
Yes.
Is that a fair and accurate representation of what was documented at placard number 1?
Yes, it is.
I would move to witness as an exhibit.
Any objection?
No, Your Honor.
It'll be marked and admitted as Exhibit 12.
Exhibit 12 still not. And if I just may publish Exhibit 12 to the jury?
You may.
And Trooper, what was there a placard number 2 on scene?
Yes, there was.
And what item was identified at placard number 2?
Placard number 2 was one of the knives and that I talked about that was contained in that box.
And where was the box located?
It was located on the dining room table.
May I approach the witness?
You may.
Another photograph, Trooper. Is that a fair and accurate representation of what was identified at placard number 2?
Yes.
I'll move to admit this is the next exhibit.
I would object and ask to be heard at sidebar.
Certainly.
Your Honor, may that be marked as the next exhibit?
The photo of placard number 2 is marked and admitted as Exhibit 13.
And if I may publish that for the jury.
You may.
Thank you. Trooper, when you were making note of the item at exhibit number 2, that knife on the dining room table, did you make any observations of the knife itself?
Of that knife in particular?
Yes.
Yes, I did.
And what observations did you make?
We noted there was some sort of a substance on there.
And so as a result of noting the substance, is that what made you flag it as placard number 2?
Yes.
Now, Trooper, you've also testified that in this case, a video of the entirety of the house inside and out was done.
Correct.
And you yourself went through the entire house with the other troopers, Trooper Watson and Sergeant Bankston.
Correct, yes.
At this time, Your Honor, I would like to play the crime scene video.
Any objection to that?
With the provisos that we mentioned before, no.
And I do have to offer as an actual exhibit the video itself, and that would be admitted subject to redaction.
All right. So it will be admitted subject to redaction. And let me explain to the jury what redaction means. Redaction just means that there's something that's been taken out of the video. And the reason that it's taken out of the video is it's not relevant to your decision making. And the early remarks of the case, that one of my jobs is to make sure that everything you see and hear inside the courtroom is relevant to your decision making. Some portion of that video was not, and it's been removed. Everyone see the video?
Objection.
I've known him since we've been 4 years old.
And where did the two of you grow up?
In Hyde Park, we're a couple doors down from each other.
Did you have a close relationship with him?
Extremely.
How would you characterize your relationship with him?
He was my brother.
And you said you knew each other since you were 4. Did you grow up together as teenagers?
We did. We went all the way up into the high school years. And after high school, we split up a little bit when he went into the military and I went to the military. It was 2 different assignments, but we stayed very close and during the military. And then after the military, we re-engaged, and not too long after that, he moved to the South Shore.
Okay.
And we were back together.
And for a period of time, did the two of you work together?
Yes.
And what type of business did you work with Michael Ricci?
We were doing fire sprinkler inspections and testing.
Did you know him to work another job at some point?
Boston Fire Department, yes.
Do you know how long he had been at the fire department?
Over 20 years, I believe.
And so when he would work with you doing the fire sprinkler work, was that a part-time job?
Yes, it was depending on his shift. They rotate shifts, but yeah, most of the time it was whatever days he wasn't working and there was no other obligations, he would come in and work with us.
And were you familiar with Michael Ricci's family?
Yes.
And how many kids did he have?
3 total, but 2 of them were his and 1 was adopted.
And did you have any special connection to one of his children?
Goddaughter. And his daughter, Sophia, is my goddaughter.
Okay.
And all 3 of them, they were very close to me. They call me Uncle Mac.
Okay. But as far as Sophia goes, you were actually her official godfather.
Yes.
Now, were you familiar with Michael's wife?
Yes.
And did you know her when they kind of started dating, or were you around when they got together?
Yeah, I was. That was kind of when Mike was working another job, just getting onto the Boston Fire Department, I think, is when they first met. So he was in transition doing his probation year with the fire department when they first met. But then after the fact, yeah, I did. That's when we kind of came back together, when his schedule got more even. And then from then on, yes.
And were you familiar when they got married, Michael and Christine?
Yes, but I was not at the wedding. That's right after September 11th, and I went to a different job overseas.
And as far as your work with Michael, when did he come and work for you at MCC?
We both worked together for another company for probably 10 years. And then as that guy was retiring, he kind of asked and suggested I started my own, which I did. And Mike came along with me. So Mike was probably with me in my role as owning the company for probably about 10, 12 years.
And then at some point, did you step back from your role as owner from the company?
Just recently, actually, I did. I dissolved it after what happened with Mike and a lot of the...
Objection, Your Honor.
All right.
Move to strike.
I'll strike it. It's not relevant. You recently dissolved the company. Next question.
When you worked with Michael Ricci, or when he worked for you, I should say, did you see him on a regular basis? If he was working, did you see him that day?
I did. It was usually 3 to 5 days a week.
And did you guys have kind of a home base or a shop that kind of business started out of for the day?
Yes, we ended up for years and years over in Pembroke. It was a small shop that was an upstairs, downstairs with a big shop downstairs.
And at some point in your personal and your working relationship with Michael, did you observe a change in your relationship with him?
Yes.
Was there a point where you didn't see him as often?
Yes.
Was that on a personal level or a professional level or both?
I believe it's kind of hard to say. We're still best friends. It's just, I think business-wise, he went in a different direction. He needed to work on some things, he said.
Did you notice a change in his behavior at work when he was working for you?
Yes.
What were your observations of him before the change? What type of worker was he?
He was great. He was one of the best guys everybody wanted to be with him, and he was a great worker. And he was always fun to be around. And
it changed. Near the end, it changed. He was not happy.
Well, let me ask you some
Your Honor,
questions.
move to strike.
Yep, stick to your observations. I'll strike the last.
When you would work with Michael, would you guys hang out after work sometimes?
Sometimes, yep. We would.
How frequently would you go out after work?
If it worked out and everybody was back to the shop in time on a Thursday, we would get together and it was kind of our informal session of complaining about everything and maintaining all the tools and having a beer or two or order a pizza and make it at the shop.
Okay, and was that generally kind of a once a week thing or multiple days?
It would usually be once a week. It was Thursday because we pretty busy schedule, and of course his schedule was different than ours, so it was hard.
And did you notice after a period of time, Michael not coming to what you called Thirsty Thursdays?
Absolutely, yeah. Well, all around he was just not around as much. Yes.
Would he come in for work and then just leave?
Yep, he would go directly home.
Did you have any issues with him as his supervisor with his work?
None.
How about with coming into work on time or coming into work on his scheduled days?
He was actually coming in on time, doing fine until maybe about 6 months before he stopped working with us. He was coming in a little bit late or not as reliable about coming in. Even on the days that he was scheduled to come in, there was a conflict of interest or scheduling.
Okay. And when you noticed this change in his behavior, did you notice any physical changes as well?
Yeah.
What did you observe of Michael specifically physically?
Okay, physically, he looked like he didn't look good. In other words, he didn't look like the Mike I knew when everybody knew, to the point where we'd ask, is everything okay? Or pull him aside, is everything all right? Because he had scratches a lot on his face, a lot. He had a fat lip. He had a bleeding nose. One time we thought his nose was broken. We asked him if everything was all right, something you want to talk about.
Okay.
Objection, Your Honor. Could be heard at sidebar.
Yes.
Mr. McDonald, do you recall when Michael stopped going out with you and the other members of the crew after work?
Yes, it was probably 2019, I believe, in that area.
Any sense of whether it was early on in 2019 or later in the year?
I remember him coming in. It was near, I believe, their anniversary.
Do you know when their anniversary is?
September. And early September.
And when you observed these changes in Michael's physical appearance, do you recall when that was in relation to when he stopped going out with the group?
He may have stopped going out with us a little bit before that as well. He was becoming more quiet, and for lack of a better word, when the guys talked, we didn't know how to approach him.
Why don't we have the next question, please?
In that fall or so of 2019, did you know Michael to be going to AA at that time?
It was around the fall, yes. He started to go to a program. He said he was going to.
Not what he said, but just your knowledge of whether he was
did for sure.
attending.
We had GPS in the trucks. I know for a fact where he was going, yeah. He went to AA and counseling.
And at that time, you had allowed him to use a work truck?
100%.
And was he allowed to take that work truck home with him?
It was, because he would use it for emergency service as well. If there was an emergency service call, he could use that truck to go to the call.
Okay. And during the same time period of the AA and not going out, is that the same time period when you made these observations of his physical appearance?
It is.
And do you recall when Michael stopped working for you completely?
Yes, it was probably 2 months after our conversation near his anniversary. So September, October, November, somewhere in that area, October, November, maybe.
And after he stopped working for the company, did he still have access to the vehicle that you allowed him to use?
I let him use the truck, and said he was looking for another vehicle, another ride. So I let him have access to the vehicle in case he could get a day off and come work with us, and obviously to help him get back and forth until he gets a new vehicle.
Did you allow him access to the vehicle so he could go do side jobs or other work
No,
with fire sprinkler repair?
no, there was no side jobs. It's under my license.
So in regards to that type of work, the fire sprinkler repair work, your company is properly licensed to do that?
It is.
And how about your employees? Are each and every employee licensed, or are they under your license?
They're under my license, and I'm the only one that can pull a permit to do a job.
And so when Michael stopped working for your business and was still allowed to use their truck, was that a personal decision you made?
He was allowed to use the truck in case there was a service call that he could jump on and respond to and make extra money, because he was trying to save up extra money to buy a truck.
Would those calls be through your business, or would he get them on his own?
No, they come through my business, my phone.
And at some point after he stopped working for you on a regular basis, you said that was towards the end of 2019.
Yeah.
Did you take the custody of the truck back?
I did.
Is now a good place to break?
Yes, Your Honor.
Jurors, I'm going to send you off to lunch. I'll see you back at about 2 o'clock. I do have a list at 1:45, so if it's a few minutes after 2 o'clock, it's just because I'm handling other matters.
The testimony and the evidence each of the court and the jury in the matter now pending from the Commonwealth will defend at the bar to be the truth, whole truth, nothing but the truth, so help you God. Thank you.
Thank you. You may proceed. Good morning, ma'am.
Good morning.
In a loud, clear voice, could you please introduce yourself to the jury and spell your last name for the record?
Janine Bouchard, Bouchard.
And what is your date of?
Yeah, Janine, Janeen.
And ma'am, what is your date of birth?
8/26/70.
How old are you?
53.
And what city or town do you live in?
Pembroke.
And how long have you lived at the location that you're currently at?
Been there the last 8 years, 9 years.
And the actual address is what?
212 Plymouth Street.
Are you employed?
I am.
And what do you do?
I'm a pediatric hospice and palliative care nurse.
How long have you been a pediatric hospice nurse?
About 8 years.
And can you describe what you do, some of your duties and responsibilities?
Your Honor, I would object to this with regard to.
She can give a foundation with regard to who the witness is, briefly.
Could you briefly tell us about duties and responsibilities in your job?
Caring for children who are terminally ill.
Thank you. And prior to you doing that job 8 years ago, were you employed in another capacity?
I've been a nurse for 20-something years, 22.
Okay. Going to draw your attention, ma'am, to the year 2018. Did you meet or know somebody by the name of Michael Ricci?
I did.
Where did you first meet him?
I met him at my stepmother's house.
And did you meet his family?
At some point.
And did you meet his wife?
That same time, yes.
And did you learn her name?
I'm sure.
Is her name Christine Ricci?
Yes.
And do you see her in the courtroom today?
Yes.
Could you please point to her and tell me an article of clothing she's wearing, please?
Light blue sweater.
Your Honor, may the record reflect the identification of the defendant?
Any objection?
No, Your Honor.
The record will reflect that the witness has identified the defendant.
And did you learn what Michael Ricci did for work when you got to know him?
I think when I first met him, I knew he worked for a friend, Mark, doing sprinkler systems.
Did you also know that he was a firefighter?
I learned that at some point.
Okay. And after you initially met Michael Ricci, at your stepmother's house, did you see him again thereafter?
Yeah, a few times.
And where would you see him?
There or where she worked at the BBC.
And what is the BBC?
A restaurant and bar in Pembroke. Or it's not that anymore. I forget the name of it now.
And BBC stands for?
British Beer Company, I think.
Okay. Is that a bar restaurant?
Yes.
Okay. And how often would you go to the BBC?
A couple times a month.
And was there a particular day that you would go?
My friend and I would meet on like Thursdays, sometimes a Friday.
And did you have a particular friend that you would always go with, or would it vary?
Usually.
Who was
the
that?
same one, Danielle.
Was your job near there, or?
Sorry, we have to stop this to jump over to closing.
Certain results. However, what you are about to hear is not evidence. The lawyers are not witnesses. All of the evidence.
Okay, so a heads up, the sound is going to be awful. Awful, awful. I'm going to not talk. I'm going to push play, let you adjust. If I'm going to come back, I'll give you a heads up somehow. I've boosted it already. It's on the max, max, max. I'm a little bit behind to keep closed captions on just in case.
Evidence in this case has been presented through the testimony of the witnesses at this witness they regard as important and based on the evidence to try to persuade you to reach a certain result. However, what you are about to hear is not evidence. The lawyers are not witnesses. All of the evidence in this case has been presented through the testimony of the witnesses at this witness stand and the exhibits which you will have an opportunity to examine and consider during your deliberations. Our rules are designed to ensure that the parties receive a fair trial and that they therefore prohibit the attorneys from making certain types of arguments in an effort to persuade you to reach a certain result or to favor or discredit either party. For example, the attorneys are not permitted to refer to facts that are not in evidence in this case. If, based on your memory and understanding of the evidence, a lawyer does this, you should disregard that comment. The attorneys are not permitted to express their personal beliefs in the credibility or lack of credibility of any witness who testified in this case. That determination, credibility, is entirely for you to make. If a lawyer makes such a comment with regard to the credibility or lack of credibility of any witness, you should disregard that comment. This case must be decided solely on the basis of the admissible evidence and the law that I give to you. Attorneys are not permitted to persuade you for or against either party by appealing to human passions, emotions, or prejudices. If a lawyer makes such a comment, you should disregard that comment. If you become conscious of any passion or prejudice as you consider the evidence and engage in your deliberations, you must put those feelings aside and not permit them to influence your thinking. And with that, we will turn to the closing arguments of counsel. We'll hear first from the defense, as is the custom. Attorney Wolf. Yes. we're going to take a comfort break before we get started. So even though you didn't have to go to the bathroom, somebody else did. So we're going to send you out. We'll be right back in shortly.
For your home? Is that why you chose to go there?
It was in Pembroke, but it was in between the two of our houses, and my stepmother worked there, so.
And when you say in between two of our houses, are you referring to you and your friend Danielle?
Yes.
Okay. And had you been going to the BBC on Thursdays prior to 2018, or was this something new?
Here and there. It wasn't every Thursday.
And did a friendship start between you and Michael Ricci?
Yes.
And how did that happen?
Just hanging out there. He would be there sometimes with a friend, Mark, or guys he worked with.
And was Mark, is that Mark McDonald?
Yes.
And was he a friend of yours as well, or did he become one?
He became, he was good friends with my dad. And when my dad passed and when he was sick, I got to know Mark more, and he stayed very good friends with my stepmother.
Fair to say that you knew Mark McDonald before you knew Michael Ricci?
Yes.
Okay. And were there occasions when you and Michael Ricci would stay later than friends to talk at the bar?
Yes, once in a while.
And you got to know him?
Yes.
And how often, and again, we're talking about time period of, I'll draw your attention to the summer of 2018, going into the early fall. Were you still only going to the BBC one time a week?
Oh yeah, no more than that.
And would you say each time you would go there, you would see Michael on Thursdays?
Not every time.
And at some point, did you and Michael share with one another the state of your kind of personal affairs?
Yes.
And did that include the state of his marriage at the time?
Yes.
Did he wear a wedding band?
No.
What would Michael Ricci typically drink when you were with him?
Bud Light.
Did he ever drink anything hard alcohol?
Not that I saw.
Any shots?
No.
And how much would he typically consume when you would be with him? Was it any amount that concerned you?
No, maybe a handful.
And at some point after learning about the state of his marriage, did your friendship turn into something more?
Yes.
And when was that?
The end of August, very beginning of September.
And did it turn into a romantic relationship?
Yes.
And how long did that last?
It ended Columbus Day weekend, so maybe 6 weeks.
And how did it end?
He had texted me that I think Sunday morning and said, "We're over. I need to end this. I will call you later. Please don't say anything. Just listen."
And did you respond?
I don't remember. I think I just said, okay.
Were you confused?
Yes.
And after that initial text from Michael Ricci, did you hear again from him that weekend?
No.
Did you hear again?
Oh, yes.
Oh,
He texted, then he called later that evening.
and this was Columbus Day weekend of 2018?
Yes.
Which would have been in October, correct?
Yes.
And what, if anything, did he say when he called you?
Basically, we're over. You never meant anything to me. It was very scripted, just a few.
Objection, Your Honor.
Sustained.
Move to strike.
It's stricken. You said it was over. You never meant anything to me.
Yes.
And did you hear from him again after that?
Yeah, a couple months, maybe a month or two later, I had several missed calls one night. I don't know, like in 10, 11 o'clock at night. I did not call him back. And then I think days later, there was another couple missed calls and then another call I did answer.
Okay. And during November 2018, so shortly after things ended with Michael Ricci, who, if anyone, did you receive text messages from?
Christine.
May I approach the witness, please?
You may.
I'm just going to ask you to take a look at it's 3 pages, just going into the top of the 3rd page, and take a look at that, read it to yourself, and tell me if you recognize it, please.
I thought you didn't have to redact it.
Do you recognize that series of text messages?
Yes.
And what do you recognize that to be?
The text I received from Christine.
And is that a fair and accurate depiction of the text messages that she initiated with you on November 6, 2018?
Yes.
I'd ask that this be marked as the next exhibit, subject to redaction. If they're actually this one, I don't think that's one.
Is there any further
renewing.
objection to this one?
Renewing my objection.
I note your renewed objection as redacted. It'll be marked and admitted as exhibit 32.
And what was the nature of her initial communication with you on this text message, ma'am?
Objection, Your Honor. It speaks for itself, doesn't it?
I'll let it go through it. Could you repeat that?
Yes, could you tell us about this? May I approach again, Your Honor?
You may.
Well, actually, I don't need to yet. Ma'am, could you tell me what the text message, the gist of the text message was?
I'll see you at the side of the bench. Change the stickers.
May I continue?
You may.
With regard to exhibit number 32, ma'am. Just showing you that on the larger screen. Is this the initial text message that you received from Christine Ricci?
Yes.
Fair to say it's dated November 6, 2018, 10:50 a.m.?
Yes.
And during the course of this conversation, that was the first time she had reached out to you, either by calling or texting, correct?
Yes.
And fair to say she indicates that she's contemplated going back and forth on what exactly she wanted to say to you. That's how she starts it off.
Yes.
And within the body of this text message, she indicates that you both had a part to play in this, and she's referring to the affair, correct?
Yes.
And then she proceeds to tell you of nothing, you have no guilt, no morals, not even a respect for your own family, correct?
Yes.
And that you disrespected her, correct?
Correct.
And now showing you page 2, this is fair to say a continuation of the initial text message we were just referring to. And she speaks about people that she knows in your family and having respect for those people. Is that right?
Yes.
And she also references the fact that Michael Ricci owns that he made a big mistake.
Yes.
And she proceeds to tell you to stay away from her husband and her family, correct?
Correct.
And that if you see her, you should walk in the other direction, correct?
Right.
And then the last page of that.
This happened when we were watching live as well. And then they just cut the whole witness testimony. It was so weird.
With regard to prior jurors, before we go further in this testimony, I'm going to give you a limiting instruction with regard to prior bad acts. You heard this earlier. I'm going to remind you of it now. You are about to hear some evidence which concerns an encounter.
I just wanted to say, I saw you need to make some emojis, which reminded me, Steve fixed up some of the member badges, but I still haven't been able to get my AdSense account verified and whatever. So making changes at the moment, like I have to verify that I am me and my ID and my payment details and all of that is right. So once that's sorted and I am verified, then I will be able to sort other things in my YouTube studio. It's just at the moment, like that's the top priority. And every time I try to do it, it takes a bajillion times longer and still doesn't work. So.
Alleged to have occurred between the defendant and this witness before the incidents which are the subject of the charged crimes in this case. This evidence is to show the nature of the relationship between the defendant and the witness and the defendant insofar as it may bear on the issues of a possible motive and the defendant's intent in this case. Like all evidence, it's up to you to decide whether you believe it or you do not, and to decide what weight that evidence should have. This evidence is not introduced, however, to show that the defendant had a bad character or propensity for violence. You may not consider the evidence for those purposes. The defendant is not charged with committing any crimes with respect to this case other than the charges contained in the indictments in this case. You may not consider such conduct as a substitution for proof that the defendant committed the crimes charged, nor may you consider it as proof that the defendant has a criminal propensity, personality, or character. You may consider such evidence solely on the limited issues of the defendant's state of mind, motive, and intent with respect to the indictments in this case. You may not consider this evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant committed the other acts, she was more likely to have committed the crimes charged in the indictments.
Court will rise to arraignment. This court's now in session. Be seated, please.
Attorney Wood, you may.
The Commonwealth never proved in this case that Christine Ricci intended to kill her husband. Admittedly, though, in order to see that clearly and extract that truth, we dig through and sift the mountain of dirt they were allowed to come in and dump on Christine Ricci in this case. We need to look through it, sift it, and categorize it, and put it in bins so that we understand what it is. And once we understand what it is, we can deal with it, we can clear it away, and we can start talking about what happened on January 28, 2021. So let's start by talking about all that dirt, and then I'll get into the events of January 28th, which are the critical period of time that this entire case is about. As I told you, every answer to every question that we have is contained about the 15-minute period on that night. But before we get there, we need to talk about the stuff that they spent most of the case talking about. Amongst the dirt that they piled up in this courtroom, I think you can sort of separate it into essentially 4 bins. There's the bruise stories that you heard about. There's the suicide attempts. There's the implication that there was some controlling behavior on the part of Christine relative to Michael. And there was all the stuff about Janine Bouchard. And I'll talk about each one of them in turn because I think it's important to get and figure out exactly what's being said and what was exactly presented to you. In the first bin, we talk about the bruise stories. And what are they? Basically, we had 5 people testify about bruising. But just because 5 people testified about bruising doesn't mean that there were 5 bruises. What do we know? Sophia was the first person to testify, and she said that sometime about 2 years before her father's death, which would have been in the beginning of 2019, she heard that an argument had occurred, and then shortly afterwards saw a bruise on the side of her father's face, near his eye, and a fat lip. Katrina Freeman came in and testified, and she said she remembers an incident in which the parties were fighting. And during the fighting, the parties went outside. And shortly afterwards, she saw Christine come back inside the house complaining about her hand. And when asked how she hurt her hand, she said, "I hit it in the face, and that's how I hurt my hand." She also testified in cross-examination that afterwards, Ms. Ricci was wearing a cast for a period of several weeks, and that Michael Ricci, when she saw him the next day, had a bruise on the side of his face, near his eye, and a fat lip. Michael Ricci Jr. testified that he, when he was still living in the house, which we know was before June of 2019, was in his bedroom looking outside the window when he observed his parents leave the house and continue an argument that had happened starting outside. And as he's viewing that house, he sees Ms. Ricci strike Big Michael. So essentially we have an event that occurs either at the end of 2018 or 2019. It happens outside the house. That's consistent with both Katrina's version of the event as well as Michael Jr.'s version of the event. We have bruising in the very same area, in the area by the eye and a fat lip. Then we have the testimony from Mark McDonald. Now, there's a few things that we learned from Mark McDonald. One is that he's no good at timeouts. But there's a few things that we know about when he would have made his observations. And we have that information as a result and as a benefit from little Michael's testimony. And the testimony is this. We know that Max says Michael's work with his company, MCC, began to taper off after he had a conversation with Big Michael about Michael's plans to leave his marriage. We know from other testimonies that that was in October of 2018. And we know that the tapering down of the work started then. And we know that Michael Jr. started working for MCC starting at the beginning of 2019. And by then, Big Michael was no longer working for him. We know that Mr. McDonald's observations occurred during a period of time in which Michael Sr. was working for him. That puts the timing sometime at the end of 2018, beginning of 2019. And what does he see? Well, he said a lot of things, but basically what he said was he saw bruising, fat lip, and then he mentioned some involvement about the nose. Now, you can decide whether or not Mark McDonald was trying to gild the lily with some of those observations. It's not consistent with the people who were living in the house with Michael Sr. at the time, who just noticed the bruising. But all of those puzzle pieces fit together. They all take place in the end of 2018, beginning of 2019. And they involve a fight that starts in the house and goes outside, and there's a hitting event. That is the same event. Katrina's saying that she sees the party or she hears the party leave the house. That puzzle piece fits perfectly with Michael Jr.'s observations from his bedroom window of the fight that is coming from the inside to the outside in the hitting event. What about Matt? We then heard from Michael Dillon. He made sort of an interesting set of observations about bruising. Doesn't attribute the bruising to anything, but he does say that in one instance, which he places sometime in mid-2019, although he's thinking back without any sort of temporal landmarks, that he sees two black guys. And then he says, several months before Michael Sr.'s death, he sees one black guy. And then shortly before Michael Sr.'s death, he sees some straggers. But that doesn't make any sense, given the observations of the people that were living in the house with Michael at that time. You heard Katrina Freeman saying she saw one bruise during that time. She'd see him pretty regularly. You heard Angel saying you would see him 3 or 4 times a week. Didn't see 2 black guys and then 1 black guy. I'm not suggesting that Michael Dillon was lying or that he was wrong about all of it, but is it possible that perhaps he may have mixed the order of those 2 events? Now, we heard from Angel that probably about a year before his dad's death, his dad got septum surgery. And as a result of that, there was some swelling around his nose and some blackening of both eyes. Is it possible that what Mike Dillon is remembering is 2 separate events, but in the opposite order? One that happens not in the middle of 2019, but closer to the beginning of 2019. This would have been a time when Michael was working for Michael Dillon. Could he have seen the very same bruises that were described by Katrina and Sophia and Michael Jr. from that same fight outside the house that went from the inside to the outside, where Christine struck Michael, he got some swelling in his eye and a fat lip, and she broke her hand? And is it possible that that second event actually happened afterwards? Maybe about a year before Michael's death, when he came in with 2 black guys. That would be consistent with all the other evidence you heard in the case. And if it's true, it means you heard an enormous amount of evidence about bruising that all relates back to this one period of time, right at the end of 2018, the beginning of 2019, in which they got into a fight. And no one is justifying hitting anybody. Christine didn't make the right choice when she did that, but it's multiply attested by several witnesses that it happened. But it happens in this one instance. Yes, there are some other. There is the testimony of Michael Jr. that in the week or so before his father's death, he went and spoke with his father, and although he had never mentioned it before, as he's picturing him in his mind, he may have noticed under one of the bags of his eyes that there was something that looked like a bruise without any attribution. But it's funny, because he was working with Michael Dillon at that time. Michael Dillon doesn't mention black and blue a week before. He was living with Angel. Angel doesn't mention black and blue a week earlier. He was living with Sophia, who was seeing him almost daily when he wasn't working. And remember, he was home a lot. He only worked, 1 day on, then he had 2 days off, and he would have one 24-hour shift on, and not 4 days off. And although he may have done some side work here and there, it wasn't the same as when he was working for Mac, when he was working all the time in sprinkler installation. That's what the evidence was. So at this point, he's home a lot. She's seen him a lot. Angel's seen him when he's home. Katrina's seen him a lot all the way through December of 2020 when she leaves the house. Then we have all the evidence of the second bin, the suicide attempts. You heard about that. In that bin, I count 3 events. There is, let's start with the last one, the Katrina Freeman testimony. She testified that on May 10th, 2020, there was a suicide attempt in which Christine grabbed a knife, held it to her wrist in the combined living room dining area room of the house, right outside the bathroom in that room. That's one. Let's go back in time about a year before that to June 6, 2019. And I'm going to suggest that the evidence suggested that there were 2 suicide attempts on that day. We have the testimony of Michael Ricci Jr. And what was his testimony? What were his observations? He said he was home. He said his mother was home. They were watching TV together. She went upstairs to take a nap, and shortly thereafter, his father got home. His father asked, "Where's your mother?" He said, "Upstairs." And the father went. Michael Sr. went upstairs. Shortly thereafter, Michael begins to feel the house shaking and hears loud voices, and he goes upstairs to confront the couple who are fighting. When he gets there, his mother's upset. She's crying. They seem to be talking about the affair. And she says the words, "Get out." Maybe at Michael Jr., maybe at Michael Sr. But Michael Sr. leaves and goes downstairs. At that point, Christine apparently closes the door, and they're having a yelling match between a closed door. At a certain point, Christine has had enough of this back and forth, and she walks out and goes downstairs, and she goes to the kitchen, and she grabs a knife. And the testimony of Michael Jr. was that she either grabs a knife from the magnet holding the knives or the block of knives. And she's holding the knife, he says, like this, with the blade outward. He's within feet of her. He's within feet of her. He says within 3 feet. He's within essentially grabbing distance of Christine. When he sees her get the knife, his testimony is he immediately grabs her. She only gets 2 steps away from that block of knives before he stops her. And he puts her arms behind her back, and he restrains her, and he brings her over to a chair, and he sits her down, and she's crying, and she's upset, and she's saying, "Get off of me," and eventually she drops the knife. And when she drops the knife, she says these words, "Why won't they let me kill myself? Why won't they let me kill myself?" Shortly after that, Angel comes home. He gets a call. Maybe it's from Michael Jr., maybe it's from one of the parents, but he gets a call. He's at work. He gets a call or he gets a text. Come home. There's been a big fight between the parents and Michael Jr. He comes home. And he's mad. He's pissed. He also has had enough of the turmoil about the affair and the fact that there's arguing now between the kids and the parents. When he gets home, he goes right up to the parents' room, which is where the 2 of them are. And they're both sitting on the floor. And in Michael Jr.'s story, just before he goes downstairs, Christine smashes the mirror. And what Angel's story is that when he walks in the room, the glass in the mirror is still on the ground. So the 2 stories match up practically completely. He says at that point, he gets into a yelling argument with his parents, and that sets his mother off, and she goes downstairs again. And this time she grabs a knife and she holds it to her stomach, almost like the way that he said, as if to poke herself, or the way that the Japanese person would commit suicide. It creates an image of what he was talking about. And then he says he restrains her, and his father takes the knife out of her hand. You heard the testimony of Lee Rivera about that very same incident, and what does Lee Rivera say? Lee Rivera says, well, when we asked him about it, she said, I want to make sure I get this right. She says, maybe I'm better off dead. That was her description of those two events. So we have these three events that all take place. And don't forget, during Michael's story, after she says the words, why don't they let me kill myself? He walks upstairs behind her because he's so nervous that she might do something to herself. And then we have the third bin, which is the bin where we have all the information that the Commonwealth wants to put on about the controlling behaviors. And what exactly are the controlling behaviors? The first part is she controlled his phone. What's the evidence of that? Well, the evidence is that Mark McDonald said that he wasn't available on his former number after he left his employ. But remember, the phone that he had was a company phone from MCC. And when he stopped working for MCC, he got a new phone. Just like when he stopped working for MCC, a little while later, he got a new truck. There doesn't seem to be anything particularly sinister about that. He got all new friends. Yeah, the testimony was that shortly after the affair was disclosed and the parties and everybody started to talk, Michael admitted that he was an alcoholic and started going to Alcoholics Anonymous. And it seems like he took it seriously. From the testimony of Bobby Higgins, who you saw, he was an enthusiastic participant in Alcoholics Anonymous. It's oftentimes hard for people who were alcoholics because their social lives revolved around drinking. And many of their friends, even if they don't have problems, they're easily able to slip back into the old grooves, the old behaviors. And so it's important, oftentimes when people are trying to get better and trying to get clean, that they start a new set of social habits, new set of social rituals, and even start hanging around with people that, in the words of Bobby Higgins, are on the same path as them. It makes things easy, makes things easier. And what do we know about Michael Sr.'s life when he was drinking? Well, a lot of his social activities revolved around alcohol. Now, they try to minimize it, but you heard the testimony of both Sophia and Angel. They both had concerns way before he ever said he was an alcoholic. Talked about the fact that he would come home and Paul shop an 18-pack. And before that, he would oftentimes go to the bar and drink and get warmed up at BBC across the street from MCC, or down the street from MCC. It seems like Michael certainly felt that he had a problem because he said he had a problem. He told people he was an alcoholic. He got involved. He followed the steps. He got a sponsor. He did commitments, which means you go to places and give a speech about your process of getting sober. So we got a whole new group of friends, but that makes sense under the circumstances. You heard from Bobby Higgins that the house at 679 Lorraine Street became kind of a hangout for all the people that were in the sober softball league and people at AA. So he wasn't being isolated. He was just fraternizing with a whole new group of people that were on the same path as he was. What's the other evidence? That she would go to AA meetings with him? Well, she didn't go to the men's group with him. She didn't write his commitment speech for him. But Bobby Higgins told you that the AA encourages people, again, encourages people to bring their family and bring their family along. And Christine did Al-Anon, and he even went to Al-Anon with Bobby. She asked questions because she wanted to understand the nature of the 12-step program. She bought books and she went back to school, and according to Sophia and Angel, she did it with sort of the idea that she was supporting Michael. It seems to me a lot of the stories of control could also be understood as stories of support, depending on what your attitudes were about Christine. And a good way of understanding what witnesses' attitudes were about Christine, a good litmus test is that alcoholism issue. Because when Michael got sober, there were people on board and there were people that weren't on board. Michael McDonald had skepticism, wouldn't admit it on the stand. Then again, he wouldn't admit much of anything. He wouldn't admit that when you're lost, you don't know where you are. His timeline kept moving from year to year. 6 months could be 2 months, depending on what he needed it to be at that moment. But Michael Jr. told me, he said, if I had any doubts when I left, he begrudgingly admitted after talking to Mac, that solidified it. And all the guys that he used to go hang around with also doubted it. They doubted that he was an alcoholic because, after all, according to Mac, he wasn't even a heavy drinker. All he drank was beer. He was the guy, Mac was the guy that drank scotch. And if Mac didn't have a problem, certainly Michael didn't. It was all just invented. The final category is the obsession with the affair, or what they call the obsession with the affair. And there's no doubt about the first evidence that the affair absolutely devastated Christine. There's just no question about it. She was initially upset at the betrayal. It sounds like the fact that Michael may have been claiming that he didn't remember certain things, or maybe saying that he didn't remember things that he did remember, was making her doubt, and not knowing if her doubt was true or founded. She wanted to believe in him. She wanted to believe the story he was telling her. But then he would slip up and say something that, didn't fit, and then she would get upset again because she would feel betrayed again. And this was a relationship with a lot of trust issues. All that stuff they talked about control, that's a relationship with trust issues. That's what happens after an affair very often. There's a lot of talk about trust, and when there's lies that come out over time, it makes it very difficult to heal because you don't even understand what it is that you're healing from. And it sounds like that was a lot of what Christine was going through. And I'm not going to argue that Christine did what all of the rest of us would do, where she reacted within an average way. She was absolutely devastated. But that devastation, after early 2019, turned into a focus on trying to figure out what was wrong with Michael. And yeah, there were many people in Michael's life who didn't believe that there was anything wrong with him. They felt that Christine was just making it all up. But Michael was telling her things that made her think that she was missing something, that she didn't understand what was going on, and she was looking for answers. She was looking for answers in the classes she took. She was looking for answers at AA. She was looking for answers at Al-Anon. And she was looking for answers by asking them questions. And yes, the people around it must have seemed like they were having the same fight over and over again. And it must have been incredibly frustrating and terrible to be around. Commonwealth elicited evidence that Christine Ricci was on multiple medications. You heard from Sophia that she had panic attacks. You heard that she had some sort of debilitating arthritis, where she would wear a brace. You heard all of this evidence that she was in counseling and therapy. There is no doubt that this affected Christine Ricci. This affair affected her probably more than a completely psychologically healthy person. But the evidence of all that dirt that was presented actually does give you a clue of the direction in which that pain was directed. From about the middle of 2019 all the way through 2020, this was suicidal ideation. This was making her doubt herself, making her wonder whether she was crazy or whether or not what she was hearing from Michael was crazy. And that type of second guessing, constantly second guessing, led her to not doubt the very ground that she was walking on. And she went to Jean's house on 2 occasions. Once they had a long, hour-long conversation. It sounds like it started out emotional. It sounded like it ended with some type of reconciliation, or at least some type of acknowledgement and a hug and a statement of forgiveness. It sounded like most of what she did during that conversation was ask questions, questions that she couldn't get answers to from Michael. Now, you heard from Janine, and obviously Janine plays sort of a, based on the role that she plays in Christine and Michael's relationship, she may have had a motive to be somewhat self-protective. But what came out was that first conversation ended at a place that was more or less calm, even if it was emotionally kind of all over the place at the beginning. There was one thing that she said. She said, well, I made the statement to her that her marriage was almost over and, you know, you had already moved on. Christine agreed. Is that credible given the evidence in the case that was said? Given all the evidence you've heard about just how incredibly devastating Christine Ricci was about this affair, that she would have just been like, well, that's true. No. Or does that sound like some sort of self-serving statement of someone who's trying to minimize and mitigate their moral responsibility for something? She can tell the truth while still shading around the edges. Christine hadn't moved on. This marriage wasn't over. Everybody said it was a good marriage. They got along, they were affectionate, they slept in the same bed. This wasn't that kind of thing at all. And she certainly wasn't agreeing that this marriage was almost over, or practically over. But what did come out of the conversations with Janine is that the focus of this conversation was Christine's confusion. And probably most of us would have just stopped asking questions, stopped trying to understand. And it's probably the fact that Christine kept trying to hold on to what he was saying and trying to make sense of it that really did drive her to this extreme of going to see him and asking these questions and having this moment where she sat down and talked with him. It also appears that she had a conversation in March, or she went over to have a conversation in March of 2020. And that conversation really never happened. It was sort of aborted before it ever began. But during that conversation, there was evidence that she was emotional. Yeah, we can't get away from that. She was emotional about it. But what was the nature of the emotion? The emotion was frustration and sadness and depression and anger and incredible feelings of self-doubt and self-hatred and suicide for that period between 2019 and 2020. But that's about Christine. That's about Christine. And that's what they want this case to be about. A famous English jurist once said that in a criminal case, in a very real sense, the trial isn't about the defendant. It's not the defendant that's on trial. It's the government that's on trial. Because in a very real sense, it's the government's evidence that's on trial in a criminal case. And the question for the jury is whether they presented enough. Was there enough? And our standard of proof, which is the highest standard of proof in the legal system, is that if after looking at all this evidence, all you know are things about Christine Ricci, and you know nothing about Christine's intentions on January 28, 2021, or you don't know what happened, your job is easy. They haven't presented enough evidence. Not enough. If at the end of the evidence you feel like you maybe know what happened on the night of January 20th, based on what the Commonwealth has presented to you, your job is easy. They haven't presented enough. Even if you think it's probable or highly probable what you think might have happened, unless you are sure to a moral certainty, then the answer is easy. It's not enough. It's the government in a criminal case that's on trial. In fact, if there's even one reasonable alternative that fits the evidence, that is a story of innocence, then your job is to say not enough. The government hasn't proven enough. So let's talk about January 28th now, 2021, and talk about a very real possibility of what occurred that day. We know that the arguing may have been going on for some time. It was going on when Sophia got home from school at about 2 p.m. She went upstairs to her room and she was trying not to pay attention. She knew that the parties had been fighting and it was sort of became commonplace at that point. So she just was sort of doing her own thing, not really paying much attention, when all of a sudden she hears banging. She hears banging and the movement of things. And then shortly thereafter, she hears her mother yell, "Call 911." And she comes downstairs and sees her father laying on his side in the living room dining room area. And she calls 911, and you heard the 911 call. You heard the emotion in her voice. You heard that her focus was on talking to the 911 operator and answering his questions. And she had partial information. And you can also, during that call, hear the emotions of Christine. You can hear her crying in the background. You can hear the wailing and the hyperventilating and the crying. And in fact, Christine is still in that position later when other people arrive at the scene. So what can we gather from that? We also know that on the night in question, what's been marked as exhibit number 8 the police find in that area this knife on the ground, right there. And that's right next to a step-up that's about 1 foot, based on the testimony of all of the witnesses who are familiar with the house. And that Michael's foot, when he was found by first responders, was on the bottom of this step right here, or I'm sorry, on the other side, here. Doesn't it make sense that this argument began to happen? And what do we know based on the prior acts? She's suicidal. She goes to that drawer and she grabs a knife. I'm going to suggest she grabs this knife right here. What's been marked as exhibit number 23, what was marked by forensics as 1-4. And she holds it to herself, as if maybe to her wrist, maybe to her neck. When Michael sees that during the argument, he gets upset and he runs into that room from the living room, dining room. And he tackles her. And as he's tackling her, she hits the ground. She still has that knife in her hand. As she's plunging that knife towards her own ribcage, just below the breast. And Michael's arms are around her. And that is the first stab. She might not at this point even know that she stabbed him, but he knows. All of his adrenaline is going, and now he's focused. He gets up, and maybe he's not gentle with her at all, and it's understandable why he wouldn't be under those circumstances. He's got pain in his shoulder, and he realizes that this is an out-of-control situation. He gets control of that arm. He might grab her to do it. He rips the knife out of her hand and runs over to that drawer. And he grabs all the knives in the drawer. And he runs over to that dining room table and he throws the knives into the box on top of the dining room table. And then he turns around to see what's going on. By this point, Christine has gotten up off the ground. And she's gone over to that drawer. She's grabbed another knife, this time a steak knife. This knife right here. This time she's holding the knife to her body, and he goes over and he starts, this time he doesn't make the mistake he made the first time. He grabs her arm first, controls the arm with the knife, and they start moving around with that knife. And as he tries to twist that arm to get that knife out, the two of them begin to turn with Christine's back right in that doorway, right in front of that step leading down into the combined living room basement. And as she pulls away to get that knife back, the two of them stumble off that ledge onto the floor, and the knife is still between them. He falls in right into the knife, penetrating the center of his chest. With such force that the soft tissues in Michael's body were compressed such that the knife wound was longer than the actual blade of the knife causing the wound. At this point, Christine is underneath Michael. The knife is between them, and Michael is on top of her. She is beside herself. She rolls him off of her onto his side, and she gets up, still holding that knife, and drops it, and turns and screams for Sophia to call 911. When 911 arrives and the police arrive, first she talks to Chris Martin. She's so emotional that he doesn't even know really 100% what she's saying. He doesn't have a complete account of what she's saying. What he's able to get out of her is a statement about manic episode and collapse. The idea that this is some sort of a full statement of what happened is ridiculous. She's just been through an incredibly traumatic event. Martin described her as being emotional, heaving, hyperventilating, crying, weeping. There was no way that he could have gotten a complete story out of her. And did she think that part of that event, maybe the part where he was grabbing her to get that knife away from her, was rough and maybe considered in that moment when she's just through a trauma? This whole event was an incredibly exciting, traumatic event. She's not an emotionally fragile person, and this has just happened. She may have an accurate memory of it, but she certainly has an incomplete memory of what has just happened. And she's trying to just say what she thinks is relevant through her tears. And Martin, thinking that he's coming to a totally different type of call, is trying to piece together what he's hearing. And he's doing the best he can. It's not his fault. But then he gets a couple things. It's not until later that they bring her into the kitchen. And they sit her down, and Sophia goes and gets her medication, that she begins to say a little bit more. That's why there's no blood on the floor. He landed on top of her. The knife up by the corner of her shoulder. That's where his blood was, right there. And he was on the blade of that knife that went in his body. All the rest of the blood was bleeding internally for the evidence of it. And that's why she might not have even known exactly what happened at that point. There's no blood around. Maybe she herself hasn't looked at herself and done an assessment of what's going on at all. All she knows is this thing just happened, and it was the result of this event, the struggle, which she conceptualized as him attacking her. And again, maybe there was some basis for that, because in a moment of his absolute worry and frustration over the circumstance, he might not have been that gentle. And then she goes to the police station. And they take photographs of her. Then marked as exhibit number 17. What you'll see in picture 17, if you can't see it on this screen, when you look closer at the picture, what you'll see is a large scratch mark. It looks like what was referred to as an incised wound on Christine Ricci's neck. And when they took photographs of her hands, you notice there's some incised wounds here on her arms and more close up. That event, which began with a suicide attempt and ended with a struggle for the knife, which led the two of them to tumble off that stair, was never intended to be a stabbing of Michael. It was never intentional. The stumble was an accident, and the fall that created the penetrating force to let that knife go into Michael's body was an accident. If the Commonwealth's evidence does not disprove that, they haven't given you enough. And if they haven't given you enough, the way we say not enough in a courtroom is not guilty. Christine Ricci never intended to kill Michael. She never intended to stab Michael. What happened was an incredible tragedy that was the result of everything that was going on in the home for the previous 2 years, but was very specific, a few minutes around, but that call to 911. And if the Commonwealth's evidence, both forensic as well as testimony, did not affirmatively disprove that story, you must find Christine Ricci not guilty. Thank you.
And for the Commonwealth, ABA Cusman.
Thank you.
Ladies and gentlemen, the only way to put an end to Christine Ricci's pain, anger, jealousy, and rage that consumed her was to put an end to the very person who caused that pain. She did so by stabbing Michael Ricci intentionally in his heart and then stabbed him again in his back. Cut his back, and I suggest to you, he injured his hands trying to defend himself from that armed woman with a knife filled with rage. Ladies and gentlemen, part of your jobs is to look at the evidence, and what's in evidence is very different than what defense counsel just spent 15 minutes of your precious time speculating about. What ifs? What ifs are not evidence. What's evidence is your memories of what those witnesses testified to. What's evidence, ladies and gentlemen, are these knives, text messages, scene videos, the state of affairs in the house, and Michael Ricci's injuries created by Christine Ricci. That's evidence, ladies and gentlemen. Speculation? That's not it. Part of your jobs, ladies and gentlemen, is not just to look at the evidence, remember, and it's your memories that govern, what the witnesses said under oath. But there's other things that I think you should consider. You should also consider, ladies and gentlemen, although we don't need to prove it, motive. What kind of motive? Well, motive for Christine Ricci to commit this crime. I suggest that's abundantly clear from the evidence. Her jealousy was her motive. What else? Motive for each and every witness under oath to take that witness stand and tell you what they did. And you're allowed to consider who they are, perhaps what their affinity is towards in terms of who they're trying to protect or who they're trying to defend. You're allowed to consider all of that. Although we don't need to prove it, the motive for Christine to do what she did. What else can you consider? Not just motive, but opportunity. Did Christine Ricci have the opportunity, the ability to do this gruesome act? I suggest to you, ladies and gentlemen, the evidence is clear that this is a woman who has tried to do this before. This is a woman whose knife of choice are the very knives that she used to kill her husband. Did she have the opportunity? I suggest that's abundantly clear. Something else that might be helpful for you to be considering, you'll hear this word a lot, is corroboration. Not just that somebody says something, but why else should you believe what they're saying to be true? That's corroboration, basically, in layman's terms. Why should you believe what Michael Ricci Jr. said? Well, part of that is to look to the other evidence, to see if what he said, for example, matches up. And perhaps if it matches up with other people's recount of events, perhaps you could lend more credibility to that. That's corroboration, ladies and gentlemen. You heard a lot from many different people for a very long time. I don't need to remind you, but what I'm going to do right now is summarize the evidence. And again, the judge will inform you, and I'll tell you now, it's your memory, it's not my memory. But I'll do my best to summarize accurately, not speculating what was said. You heard first from Sophia Ricci. Clearly a difficult time for her. Clearly, she still loves her father and her mother that stands on trial for murder. What did she tell you, ladies and gentlemen? She told you that she had a happy childhood. And then everything changed in the fall of 2018, which is kind of a common theme amongst everyone in that home. And they're testifying. What else did she tell you? She told you that on January 28, 2021, she heard yelling. She got home from school around 2 o'clock. So in terms of a timeline, defense counsel has tried to establish that there's a 15-minute segment. There's been no proof of that, ladies and gentlemen. The only times, if I could remind you, that we know of is that Sophia Ricci got home that day at 2 o'clock. We know that Michael Ricci went to Dunkin' Donuts at 2:20 because you have the video footage of that. And then we know that upon him coming home, that's when Sophia Ricci heard yelling and banging, as you might recall. And then the next piece of timeline we know about is approximately 4:48 when 911 was called. That's your timeline, ladies and gentlemen. Need not speculate. That's your timeline, and we know this because it's in evidence. And what else did she say? She said she heard the banging, she heard the yelling, and her quote was, "I'm used to it." She's used to it because it happens all the time. You heard it from multiple witnesses in that home. It was a daily occurrence. And what was it always about? It was always about the affair. She was obsessed, I suggest to you. So Sophia was used to this. Nothing new here, but this differed on this one occasion because her mother yelled to her, "Sophia!" She runs down the stairs. "Call 911. Defense has tried to establish that maybe the defendant was so inconsolable and nobody can understand anything she said. Well, Sophia heard her call her name pretty clearly. Sophia then testified that she heard her mother tell her, "Call 911. And then the next thing she told her to do was go upstairs and get her cell phone. So this is a woman who defense wants you to perhaps believe through the evidence that was incomprehensible and not, you're unable to understand her. Maybe she told everyone about this stabbing and nobody heard her. Well, you heard from her own daughter that she heard her quite clearly on those 3 separate occasions. What else did Sophia tell you? That her mother did not tell her what had happened. Why is that important? Because it corroborates the fact that the defendant also didn't tell any of the first responders. So again, looking for corroboration. Why believe the first responders? Look to Sophia. Why believe Sophia's account? Look to the first responders. That's corroboration. She also told you her parents were fighting weekly. She said 1 to 2 years before this event on January 28th, she did see a bruise on her father's face following an argument with her mother over the affair, I suggest to you. She recalls her mother would be repeatedly, again, a common theme, repeatedly asking for details about the affair. And when he wouldn't remember or say he wouldn't remember the details, she would get upset. And her quote was, she needed to know the details. Again, I suggest to you the evidence is clear. This woman was obsessed with learning every ounce about that 6-week affair. She also testified that her mother tended to start the arguments. Also, she said her father, the alleged victim in this matter, Michael Ricci, was never, ever violent with her, with her mother, with anyone. So when you're trying to think about, I know Michael Ricci's not here to tell us about himself, think to all the people who knew him best. when you're trying to think about what kind of man this was, and by no means, ladies and gentlemen, do we condone an affair or his behavior or think that lots of drinking is okay. By no means is this a perfect individual, but you heard a lot more other things about it. In fact, you heard, and I'll go through the evidence, that upon the affair being revealed, that man, Michael Ricci, did everything possible He did everything possible to save and salvage the family he loved so much. Everything. Angel Ricci testified too. Again, difficult. Difficult for these children, I call them children, they're adults, to have to come in here testifying about their mother when their father is no longer with them. What did he tell you? He was adopted by Michael Ricci in 2004, called him dad. After, had a happy childhood, after the fall of 2018, found out about the affair, he noticed changes in his mom. What were those changes? She was more secluded, she was angry, she yelled a lot. In fact, his quote was, and again, it's your memories I govern, there was no getting away from it. The fights were ongoing. She was persistent about getting the truth. He explained that his father picked up the slack, and his quote was, tried to fix everything that was going on in the house. He explained that typically during fights between his parents, what would his father do? Again, trying to piece together what kind of man Michael Ricci was. He, I suggest to you, was the diffuser. She was the instigator, as the evidence showed. He diffused it. How do we know this? Everyone testified that lived in that home what he would do during the argument. He would remove himself. He would walk outside and smoke a cigarette. What else did he testify to? That on Mother's Day of 2020, and he had trouble with dates, and I want to get to that, ladies and gentlemen. Trouble with dates and confusing incidents. I ask you to think, when you're using your common sense, imagine for a moment, last year you witnessed 12 accidents. And then you were asked to come in and talk about every single detail of every single accident. Do you think you could do it? I mean, maybe. But compare that to one accident that you witnessed. Probably your memory would be a little bit easier to reconstruct about what you saw, what you heard, what you know. I suggest to you, this was repeated abuse at the hands of this woman to Michael Ricci. And lots of people saw it, and there were lots of different events. And because of that, I suggest to you, how disturbing is that? Her own kids can't keep track of all the times and all the different incidences that their mother hurt their father. So think about that for a minute when you're thinking about, well, should we believe him? I mean, he got confused a little bit with the case. Well, what he did say on redirect, as you might recall, is that on Mother's Day 2020, the same incident for corroborative purposes that Katrina testified to, that he referred to as mom poking self with knife incidents. He gets home, his parents were fighting about the affair, his mother was hysterical, there were things broken. He sees his mother grab a big Japanese-style knife and appears she was going to plunge it into herself. Angel, her son, calls for his father to go help. And the two of them are able to get that knife out of her hands and hide all the other knives. He said his father was, quote, trying to do what he did every day. Just deal with it. He also indicated the defendant and the situation progressively got worse. Moving on, you heard from Officer Hunt and Officer Martin, two of the first, actually the two first police officers to respond to the scene on January 28, 2021. They both believe they were dispatched for a medical. Why is that important? Because that's what was told to them through Sophia, because the defendant failed to tell anyone what she had just done. Why? That's called consciousness of guilt. She's trying to hide what she had just done because she knew what she had just done. Not sure how she thought she'd get away with them finding the stab wounds, but that's not for us to decide. Officer Hunt testified that the defendant was upset, distraught, difficult to understand. However, when Officer Kelly asked, only after they find the stab wound from the EMTs, Captain Smith testified to this, they ran in and said to the defendant, who stabbed him? Only then does she say, that's what I've been saying, he's bipolar and schizophrenic. Unfortunately, that is not what she was saying. And that's unfortunate for Michael Ricci. Because had she said she stabbed him, perhaps the help would have been quicker or different, or the response would have been different altogether. She then indicates further detail to help herself, consciousness of guilt and self-serving statements. She took a knife out of the kitchen drawer to defend herself. Again, she never says this until they find the stab wound. I suggest she had plenty of time to manufacture a story that would help her during all the time it was taking for them trying to save Michael Ricci's life. And I suggest to you, all of these first responders had years of training, and they all testified to it. They're used to traumatic events. You better believe that if any of those 4 men that testified under oath, or 5 men testified under oath, they did not hear her say anything about a stabbing, I suggest to you, you could believe that. Because had she said anything remotely sounding like, I stabbed him, or he came at me and I had to stab him, they would have responded differently. That's what their jobs are for, to respond and help. And know what? Their help is only as good as the information provided. And she failed miserably with that. Officer Martin also testified that the defendant told him conveniently, he had a manic episode and just collapsed. Again, self-serving statement. Tells them nothing about the situation so that they can help him appropriately. And no trouble understanding those statements, her self-serving statements. Only after confronted with the stab wounds, Officer Martin said it all kind of came together and they all realized that she had just stabbed him. Even if you believe her self-serving statements, that he had a manic episode or that he lunged at her, even if you believe that, ladies and gentlemen, which I suggest the evidence proves you should not believe that, but it's up to you. I suggest, ladies and gentlemen, how does that explain all of the other injuries? If he lunged at her, maybe that would explain the 1 wound. How do you claim self-defense, ladies and gentlemen, or that you had to be put in that situation when you also stabbed him in his back? She stabbed him in his back. She stabbed him in his heart. I never told anyone until they found those wounds. Robert Higgins testified, Bobby, from AA, you might recall. He testified that a few weeks before his friend Michael Ricci died, he saw him, and he saw him looking tired, gaunt. He looked like a man, I suggest to you, that suffered 2+ years of verbal and physical abuse at her hands. That's who he saw. I suggest to you he was fairly unrecognizable. And what does that corroborate with? Michael Jr.'s testimony about when he went to visit his father at the fire station. What else did he say? That's if you're questioning whether or not to believe her kids about all the broken things she used to have around the house. What did he take her shopping for? Mirrors. Lee Rivera testified from DCF, you might recall. Why is her testimony important? Again, looking for corroboration and why you should believe certain people's testimony versus others. She testified to the same event I suggest to you that Michael Jr. testified to, which was the June 6, 2019 incident where ultimately he described, and I'll get to it, Michael Jr., that his mother was going after his father with a knife, running towards the father, like this. And DCF becomes involved because Michael Jr. is so fed up, so tired, so upset by everything going on for the last 2+ years, or actually for the last year, because then he moves out, that he punches a wall. And then ultimately goes to the hospital after a friend tells him, you gotta go treat that, goes to the hospital and they file a 51A report. Lee Rivera does an investigation, and in the course of her investigation, she meets with the defendant, Christine Ricci. And why is that important? Well, Christine Ricci says, yet again, she and her husband were arguing about the affair, and her husband became upset because she continued to bring it up. Michael Jr. gets home and yells at them to stop. This is all her words to Lee Rivera. She then says, so when curious about, can we believe all the statements about Christine? In her own words, Christine says, I was in a fit of rage and grabbed a mirror in my bedroom and smashed it on the floor. She also denies any physical abuse. Interestingly enough, Christine Ricci is showing kind of a pattern here. She tells just a little bit, just like on January 28, 2021. She fails to tell the whole story. And the rest of the whole story is that she grabbed a knife and went after her husband on June 6, 2019. She stopped short of that. However, the important part is she was in a fit of rage. Her own words. Detective Davis testified. I won't get into too much detail, but he basically summarized everything that transpired from the moment that the police got involved all the way through to all the testing of the evidence that you have at your fingertips. You found out that through crime scene investigators and the state police that there were many things collected. You have Michael Ricci's shirts in evidence. I ask you to take a look at the holes in those shirts, ladies and gentlemen, signifying where Christine Ricci stabbed him. I suggest you also have the knives in evidence that have, for all intents and purposes, in layman's terms, you heard the lab technicians or crime scene talk about and DNA experts. Michael Ricci's blood's on those two knives. Those two knives are in evidence. One of those knives matches the very knife by the feet of Michael Ricci that you'll see a picture of. That's in evidence. His blood, not her blood, his blood. What else is important? Her shirt was taken into evidence. What is to have on it? His blood. I suggest, you heard from Mark McDonald, Uncle Mac, we'll call him, who was a very close friend of the entire Ricci family. Yes, Michael Ricci was his best friend. He called him his brother. But he also was handpicked to be Sophia's godfather. That's how important he was to this family, how close he was to the family. And what did he tell you? He told you that he would go Thirsty Thursdays with Michael Ricci, and they'd go to the BBC in Pembroke. He also described to you that he actually saw scratches on Michael Ricci, a bleeding nose, fat lip, and he observed this all following the fall of 2018, which is when the affair was disclosed. He indicated that Michael Ricci stopped looking like the Mike he knew after the affair was revealed. He was more quiet, withdrawn. I suggest to you he looked like the battered man that he was. He also told you about two interesting events. Told you about the time that Christine Ricci and Michael Ricci surprised him at work, you might recall. And Christine Ricci did 90% of the talking, and it was supposedly for part of his AA treatment to make amends, which is interesting considering Michael spoke almost nothing. And how did he describe Michael? And again, getting to know Michael through the words of other people who are closest to him. Michael looked tired during this meeting, hunched over, only looking up at the very end. Not the same guy he knew and loved. And interestingly enough, that was an example of not just how Michael appeared during this, what I submit to you as an abusive relationship, but also how Christine appeared and the changes in her personality, which corroborates a lot of other witness testimony. Janine Bouchard, for example. Michael Jr., for example. And what he told you was that the defendant, Christine Ricci, not only did most of the talking, but was calm in the beginning, and then all of a sudden, something triggered her, I suggest, and she snapped and started screaming. This is at a place of business, to the point where he asked her to stop. Please be quiet. Help them to leave. He described it as night and day from when she first walked in the door. And he said, Michael Ricci never said a word while she was screaming. That was the last time he saw his best friend. And then thereafter, he could no longer contact him on the phone number. No longer worked. What else did he tell you? The incident about when the defendant was trying to find Janine. And what did he tell you about that? He got a call from Michael Ricci. And although he wasn't, you didn't hear any testimony about what that conversation entailed, he was worried and asked him to call her. So he called the defendant. Again, they have years and years of a relationship together. I suggest there was a lot of love between this whole family and Matt. And he called the defendant, and he said that the defendant said, I'm trying to find Janine. She was angry. Then she became calm. Then she started laughing. And then her tone change became angry. And then all of a sudden, she came upon mailboxes, which had Janine's last name, I suggest to you, as well as a Ricci. Ironically, the Ricci name was on another mailbox right next door. And she began to become erratic, screaming, he said. He had to calm her down. He also described, ladies and gentlemen, that according to his observations, Michael Ricci was doing anything and everything to save his marriage. If that meant going to AA, that's what he would do. If that meant he stopped drinking, that's what he would do. Go to therapy? Sure. Anything. Anything. While he's doing anything and everything, she's berating him, hitting him, yelling at him, but he doesn't give up. Michael Dillon, the fire chief, testified. He testified that he knows Michael Ricci very well. Why? They work together. In April of 2017, Michael Ricci was asked and vetted to be his aide. You might recall I kind of described it kind of like a golf caddy. He kind of helped him with decisions, where to go, what to do. He was his right-hand man. And he discusses the criteria he used to pick an aide. Steady head, very responsible, well-liked, great at completing tasks. And what did he say? Michael Ricci exceeded the criteria. Why is that important, ladies and gentlemen? Well, defense has tried to elicit evidence and make you believe that Michael Ricci was this raging alcoholic. When? First of all, so remote from when this incident occurred that if the understanding is perhaps he was such a raging alcoholic that prompted this stabbing, nothing is in evidence about that. So we're talking about basically the same time that he was handpicked to be a fire chief's aide. He wants you, or he's arguing that you should think that Michael Ricci was this raging alcoholic. I suggest to you, he testified that he saw no observations of anything remotely lending to that story. He also testified that he made certain observations that are important. 2019, 2 black eyes. His affect, Michael Ricci, somber. A few months before the January 28th incident, he came to work with 1 black eye. A week before, I suggest he was murdered, scratches on his neck. He also indicated that he had no concerns about anything that Michael Ricci was doing outside of work. With his memory, his drinking, nothing. Katrina Freeman. Why is she important, ladies and gentlemen? I suggest to you she has no skin in this thing. The last contact she had with this family, first of all, it's not her family. She's no longer in the family. She's no longer dating Angel. It's been years, but she was privy to 4 years of what was going on in that house. 4 years. And I ask that you think back to her testimony. She moved in there 2017 into the Ricci household.
and lived there until 1 month before this defendant stabbed Michael Ricci. And during that time, she said initially in 2017, things were pretty great. Family dinners, they did a lot of laughing, watching movies. She was very close to Christine Ricci during the entire time, even when things were not good in the home. They still maintained a close relationship. In fact, when Christine Ricci discovered the affair, who did she reach out to? Katrina Freeman, and asked that she and Angel come see her. After that event, Christine, that prompted Katrina and Angel to go to that friend's house where you might have remembered Christine Ricci seemed different. She was smoking. She doesn't usually smoke. And then she proceeded to tell them he had an affair and we're done. Basically, he's moving out. And then she said, but a few days later, everything changed. She said, actually, we're going to start to work on it. We're going to just work on this. It's going to work. She also testified that after that affair was revealed in the fall of 2018, the house was depressing, fighting constantly. The defendant, only the defendant, was always yelling, crying, and asking questions about the affair. She said that she actually talked about it at the end of 2018, where the defendant punched the victim in the face. Where the defendant punched the alleged victim in the face, Michael Ricci. And how do we know this? She didn't witness it, but she heard the fight, and then the defendant told her about it. I punched him in the face. And then she recalls her getting medical treatment for her hand. She remembered the defendant screaming, "I want answers!" She needed details. It was fueling her. She needed to know more. She indicated Katrina that the defendant stayed in her room most of the time. She was surprised that Michael Ricci went to AA because she never saw him abuse alcohol. I suggest to you, the defendant planted the seed of alcoholism. I mean, we're not saying the defendant or Michael Ricci didn't drink, and maybe drank too much occasionally. But I suggest to you that the evidence has showed that she planted this idea in people's head because she needed some reason to understand why he could ever do these things. And she was embarrassed, I suggest. So that was the story that was gonna be. He's an alcoholic, makes bad choices, and look at this. Because of alcohol, he cheated on me. She also stated that he stopped seeing friends. She never saw any issue with memory loss. And when I asked her specifically, did you ever see injuries to Christine Ricci, other than when she punched him in the face? And she indicated, yes, actually. I would see cuts on her hands. And I said, did you know how those were caused? And she said, yeah, they were self-inflicted. Think about that for a moment when you're looking at photographs. She also talked about the Mother's Day 2020 incident, again, corroborative of other people's testimony about the very same incident, where the defendant held a knife to her chest. Katrina got home. Mother's Day is hard. She had been drinking. She went inside and then ultimately went down and saw the defendant on the ground with a knife being held against her. And Angel and who? Michael Sr. were trying to help her, trying to get the knife away, a common theme. Trying to help the very woman that ultimately kills him, I suggest. Jeanine Bouchard testified, the other woman. You don't need to like what happened, but I suggest to you, she shared enough of what her mindset was, and that was based on what Michael Ricci told her. And then the defendant adopted it, I suggest, by saying, he told me you guys were done. You weren't wearing your wedding bands. You were seeing someone else. He told me you guys were done. And she said, well, yeah, she agreed. And then at which point Jeanine said, this was during one of the many conversations, she said, well, then if that's the case, what, I know, like, I should have waited probably until you were divorced, but if you're saying all these things, what? I'm sorry, but I'm not sure it's kind of as bad as it's being made out to be, if you guys were done anyway. She also said, ladies and gentlemen, that their affair was brief, 6 weeks toward the end of the summer of 2018. And Columbus Day, Thursday of Columbus Day, she indicated,
There had been some sort of a plan. She believed that Michael Ricci was going to be sitting down with the family to let them know that he's no longer going to be with Christine Ricci. And then a couple of days later, surprisingly, she gets this random call from Michael Ricci doing a total about face, saying, "You never meant anything to me," in a monotone voice. "You never meant anything to me. I love my wife. I never loved you." Big change. Totally understandable that he could change his mind or think differently or who knows. But that's what you heard under oath. She then indicated that after that conversation, she was done. I suggest their relationship was over. Yet she kept getting calls, missed calls from Michael Ricci's phone. And then on November 6, 2018, you have it as an exhibit, the defendant texted Janine. And I'm not going to go through it all, but basically just about how this woman has ruined her life, taken her man, it's her man. You could read that yourself. And then December 2019, just showing the pattern during the same time of aggression by the defendant unannounced shows up at her house at night, knocked on the door, screaming, "How could you do this to me? This is my husband," screaming and crying. And what is she saying to her? "I'm truly sorry. I thought you guys were done." Again, not wearing the rings, thought you were seeing somebody. And what was her response, I asked? She agreed. All true. The defendant said during that conversation that during any of the two conversations that she spoke to Michael Ricci when he was breaking up with her and ending things, that Christine Ricci was on the phone. So when we talk about controlling his phone, look no further. That's one example. She also indicated, Janine, that the defendant needed details, was demanding details. She was crying, angry, then calm, then yelling. She was all over the place on that event. Now, fast forward to January 30th, 2020. More text from the defendant needing to talk to Janine. She needs to know about more dates, needs to know. And Janine said, "No, not going to do this." Now, fast forward, March 18th, 2020. That's the daughter event with Janine, where her daughter had to call the police because this woman wouldn't leave her home. The defendant comes, won't leave, and screaming the entire time, "I need to talk to her, I need to talk to her." And Janine said, "You tell her I'm not talking to her." This is the second time she's come to her house at night, unannounced, demanding answers, refusing to leave, only leaves when the police get there. She described Michael Ricci as kind, sweet, calm. She actually never saw him drunk and never noticed any memory issues. You also heard, ladies and gentlemen, from Michael Ricci Jr. He described to you, ladies and gentlemen, what it was like living in that home. What did he tell you? The defendant, who he calls the defendant, constantly bringing up the affair. Do you love her? Are you going to start a family with her? Have you had sex with her? Never, ever, during any argument, did he testify that he ever heard his father screaming or yelling. Only his mother. He would, the defendant would keep asking Michael Ricci the same questions over and over again. And then in 2018 to 2019, he saw his father get punched in the face by his mother. Who does that corroborate? Katrina Freeman's testimony of the same event, where the defendant told her, "Yeah, I punched him in the face." He talked about how he would overhear his father say, "Stop hitting me." He would hear furniture breaking. House was shaking. He would come home from work and see shattered items all over. A golf club broken into, a glass door, a glass table, mirrors cracked. Then he talked about June 6, 2019, when he broke his hand, the knife incident. He indicated he was watching TV with the defendant. All was well. And then the defendant went upstairs. It's the middle of the day. He says his father comes home, asks, "Where's mom?" Up the stairs. He goes up. At that point, the defendant, he hears them fighting, Michael Jr. He goes upstairs, the defendant grabs a mirror and throws it to the ground and yells, "Get out!" And he sees his father say, "All right, I'm out." And he walks out. And where does he go? Same place he always goes during the fight, to defuse the situation. Get away from her, let her calm down. He goes outside to smoke a cigarette. the very door that was so close to where this defendant killed him. He indicated that after his father left the room, he tried to calm his mother down, and then his mother got more and more angry, saying, "You're siding with him, you're siding with him." She runs downstairs, she follows after her, she grabs a knife, and she holds it out. He described it with his hand, and I put it on the record in a right angle, I described. And he indicated from his body, and I suggest it's your memories that govern, running, he said she was running towards where my father had just went out. Body forward, I suggest. What is that indicative of? Does that sound like somebody who's going to use a knife on herself? Perhaps her mindset shifted a little bit. When she knew she couldn't go after him, she then maybe wanted to use it on herself, which was a pattern. We don't know, but we can only find that out from the one eyewitness to that, and that's her own son, who told you exactly what he saw that day. And he was scared. And he was scared that she was going to hurt her, his own father, I suggest to you, and scared she was going to then hurt herself. What did he tell you? She was angry, hostile, incoherent, hysterical, at which point he yelled to his father, "Come in, grab all the knives." At that point, he said his mother then, he had to wrestle, put her arms behind her back. Finally, the knife was released from her hand. The situation appeared to be calm, and then his mother ran back up the stairs where she had just smashed the mirror, and he was scared she was going to do something upstairs. So he followed her upstairs, at which point he was so angry, so done, so upset about the years he's been watching this and hearing this happen, he punched the wall. What else did he tell you? The defendant would look through his father's phone. His father hadn't changed his number or did change his number. Don't know why. His father was isolated from friends, including his best friend and godfather, Matt. What else did he tell you? Family meetings. Not sure if you recall that line of testimony, but let me paint the picture that he testified to. He described it as one of the many, many times that the defendant would say, "I need answers, I need more details, I need them, I need them, I need them." And then when she would find out a little bit more, she'd call everyone in. Her kids. His father would be sitting in a chair with the defendant standing over him, sharing with them the new details she found out about their father. And she'd be screaming at their father. He also described, ladies and gentlemen, that the 1-year chip at AA, it looked like he wasn't allowed to say a word in describing how his father appeared. He then described, ladies and gentlemen, that he visited his father for the very last time he saw him 4 days before January 28th. And what did he describe? His father lost weight, had gray hairs, bags under his eyes, some bruising that he now recalls. They had a 3-hour talk. And what prompted this, ladies and gentlemen, was a call from Sophia, who I suggest did everything to try to paint a little bit, minimalize kind of what was happening in that house. And I understand that. I get it. But Sophia had called them to say, they're still fighting. They just keep fighting. At which point, Junior took matters into his own hand, went to the firehouse. He had the text message saying, "I'm here, can I stop by?" And proceeded to talk to his father for 3 hours, man to man, saying, "Stand up for yourself. You're not happy. Show courage to Sophia and Angel." And what was his father doing? Not much talking, but a lot of crying. Imagine his son was kind of fathering him. And then it ended with a hug. "I love you." He described that his father was his hero. He described that his father, he observed no issues with memory or with alcohol. He was only told these things by his mother. And he then ended by talking about why defense counsel asked, "Well, you resented him, or you resented her because she kept bringing up the affair. Like, maybe that's why you're testifying this way." I think it's the insinuation. And he said, "Well, yeah, she brought up the affair every day. She also was aggressive, physical, and violent." Dr. Martinez was the tail end of all the witnesses that he sat through. I need not remind you, but she described that the Michael Ricci Sr. was 5'10". So even though Angel testified at 6'4", he was 5'10". That was what the doctor said. She measured him. It's in his chart. And she described that she examined Michael Ricci's body. He had a stab wound in his heart that was 3 centimeters in length, about 15 centimeters in depth. Through the probe, they realized this. And that wound path went through subcutaneous soft tissue, piercing through his rib cartilage, his pericardium, piercing his heart in multiple places, and causing an accumulation of blood around his heart and a collapsed lung. That's just one wound. Then turned him over where the defendant had stabbed him in the back left shoulder, and described that as a 3.1 centimeter in length by 6.6 centimeter depth through soft tissue and muscles of the back. Then she described a third wound, an incised wound to his back, and then fresh abrasions to his hands. That's what Dr. Martinez said, and she confirmed that, not that it's any surprise, he died from the stab wound to his heart. That was the evidence, ladies and gentlemen, as I recall it. Again, your memories govern. So if I'm wrong about a detail, it's your memories. And you heard a lot about other acts, and the judge will instruct you on it as she's done throughout the trial. But I suggest to you, the Commonwealth is not trying to distract you with the bad acts. You need to know about the pattern of conduct and the level of hostility that this woman had for her husband. You deserve to know about that, because else you're not knowing the full picture. It would seem isolated. You also, ladies and gentlemen, these other injuries, these other acts, it also can be used to negate any claim of accident or self-defense. And again, you'll hear all of this in the judge's instructions, I suggest. But the fact of the matter is, had they not had the benefit of hearing about all the other abusive behavior at her hands, perhaps you might maybe give a little bit of credence to the defense counsel's closing argument, 15 minutes of pure, unadulterated speculation, not based on evidence. But you have the benefit from so many people hearing and telling you about so many injuries, black eyes, scratches, bloody nose, bloody lip. This went on for 2+ years. Michael Ricci became Christine Ricci's human punching bag. She took out her anger, aggression, embarrassment, jealousy, and rage on the man that she supposedly loved so much that had cheated on her for 6 weeks. Defense counsel, ladies and gentlemen, argued a little bit about heat of passion, and you're going to be instructed on it. There's something called heat of passion on reasonable provocation. You're going to be instructed on it. I suggest to you that you would need to find that this defendant was provoked by Michael Ricci. And how do we know she wasn't? Look to the past. There's not one piece of evidence to suggest to you that on this day or any other day that he provoked anything. He was the diffuser, the calm one, the one who removed himself from situations, the one who wrestled knives at his wife's hands so she wouldn't hurt herself. That's who Michael Ricci was. So there was no heat of passion due to reasonable provocation. It was the same old, same old. She wanted to erase the past, but in doing so needed answers. And when not getting answers, she couldn't handle it anymore. There was also no mental impairment on behalf of the defendant. The only evidence you heard was that she would have panic attacks. And yes, did she try to kill herself before? Sure. There's no evidence that on this particular day, she was in the midst of having a panic attack when this happened, or in the midst of feeling like some sort of craziness was going on. All you know is that they were arguing, there was banging, and then she stabbed him 2 times. And the only evidence of any maybe mental impairment is afterwards. After she knew she had just killed her husband, I suggest to you, she has a panic attack. I suggest I might have one too. If I had just pierced a knife into my husband's heart.
As stated in the opening, ladies and gentlemen, by my sister here, Christine Ricci was like a simmering pot of anger, jealousy, rage, and control that boiled over on January 28th, 2021. She spent 2 years doing everything in her control and power to control and isolate Michael Ricci. Yet she managed to lose all self-control in doing so. And ultimately, she picked up a knife, just like she had done on other occasions, showing that pattern, and killed her husband, Michael Ricci. That's why we're here. It's not a pile of dirt, ladies and gentlemen. It's their lives. Find me guilty.
I'll see counsel to set the bench.
I feel bad coming in and talking. When the cats are being so cute, I can't deal with Frank. Vaughn, it's a bit dark.
Sorry?
It's a bit dark there. Frank is like just a void in the picture. Are we sorted? I'm eating an ice cream. And Vaughn's giving surprise appearances of tippy taps. This is, can you hear me now? Okay, my mic was muted briefly. I need to figure out how to share this without cutting where the cats are. Okay, so is the laser off? Oh no, there it is. Everybody left. They're bored of the laser now. Vaughn probably said, oh, whoa, there's one. I want to go back and see when her butt would like practically crash with the camera. Okay, so I made these autopsy pictures because theirs were awful, but this is an accurate, mostly accurate angle. And that was the chest one. Didn't go through any bone. It went through cartilage, tissue, and muscle. The back was like, in fact, even smaller than that. Oh, that's why I couldn't get it smaller, but it was like half of that here in this part of the back. And then the hands, I used the hands as normal, tiny little stabs. This is the same hand. So there's two ways that it could have happened. Either she went under, which is kind of works with falling, right? Or from above, which would then hit the cavity. And the other thing that, where can I put my ice cream? So she was wearing a brace kind of similar to this, but even less flexible. So what I was trying to show is these braces make it pretty hard to grip things. So to grip the knife this way, which is consistent with what she tries to do, makes sense, because then to him misses the ribs and the sternum, etc. And then this way, this is like really difficult with the brace on. Like I can't really get any grip on it. So if someone were to fall into that, the knife would just fly out of my hand. It's like I wouldn't be able to have enough force, because also then if you're going through this part, you're going through the cavity, etc. So I kind of understand the theory of him falling, because it also means that it takes, someone just crashed into something. It takes a little bit of pressure off her wrist having to do it. Trish, I don't think I would be able to have enough strength in my left hand. And it was on the side that it would have had to have been her right hand, from what I did yesterday when I was testing with Vaughn. I'm a little concerned about what Vaughn looks like given these drawings. He doesn't look like this. I just went and found a person who was standing in a way that I could make it work. But if you see this, where it is, for it to be a left hand, the knife would have to be sideways, like back sideways, which would be a bit strange. And I don't think she'd have enough strength. Also, she's still sitting in the courtroom. Oh, I shouldn't eat ice cream on camera because there's perverts out there. When I was in radio, we used to do lives, and then the person I worked with used to say hi to the perverts, and I'd go, hi perverts. Now that's what I think of. Use the left hand to brace the right. It's still in my hand closing. I can't, it had to have gone down. It had to have been from the bottom up. Like the only way it could only have gone, it could only have gone this way. Also, I can go back to the recap soon, but I just want to see. We passed the pervert stage with the feet cam. Any super chats go to the feet. No, I'm joking. Please don't send super chats. I don't want to pay Vaughn. Sorry, Vaughn. Can you hear me? Pardon? Okay. If you're in a relationship and a lot of your relationship doesn't consist of what? Sorry, can't hear you? Then can't relate. Yes, I can't close my hand completely around the knife with the brace on to angle it that way. I can only do it that way. Okay, well, we might as well. She's sitting so still. Evie, I think so. Something that a few people might have missed in the recap so far because I haven't heard anyone say it this morning, but she had a tendency previously to try and do that. They called the authorities on her. Yes, it did. Slightly upwards, and it was no, that way. So consistent with bottom up. I just want to finish my ice cream, so I'm going to remove myself for a okay. I am thinking that I want to fun to practice. It's just practicing. That's funny. I think I want to hop over to Judge Fleischer for a bit. Wind down our brains. Oh, wait.
She messed it up.
Don't.
All right. May I have him sworn? Do you solemnly?
We might have an update here on Brazilian woman stabbing. Not stabbing. Accidental overdose ? Wait, didn't we watch this lady yesterday? I just want to skim and see.
We screen for sobriety court. We're going to see if he qualifies.
9 a.m. bond continue.
Thank you, Your Honor.
Thank you. Calls the case, People versus Aaron Hawkins. Natural for the people. Hello. Hello, sir. Hello. Who's got this case? Ms. Cannon? Hey, mister. Hang on, we're just waiting for your attorney to come into the courtroom, sir.
I'm wondering if the veteran I covered is at the end of this, but I don't want to skip through too much because it's going to be distracting.
Stephanie Cannon with the Public Defender's Office on behalf of Mr. Hawkins, who's appearing by Zoom. Mr. Hawkins, could you please state your name for the record?
Aaron Hawkins. Thank you, sir.
Thank you. Your Honor, in this particular matter, my client is going to be screened for sobriety court. We're going
You need to hear before we begin any of the deliberations. So I'm going to send you. So jurors, I understand from the powers that be, that would be the court officers, that your lunch is here and you're probably ready for a break. We're sort of not done, not to the point where you can start your deliberations, because I have second part of my charge, not specific to the charges in this case, but important instructions that you need to hear before you begin any of your deliberations. So I'm going to send you off to have your lunch, but do not begin deliberations. Just like before, no discussion about the case at all. All right? I'll see you back here in about half an hour.
The court all rise for the jurors, especially no vote on the chair. Sit right this way.
Just want to see if they're going to discuss finding the jury instructions in the meantime. Okay, I think it's safe to say they're on break. All right, I'm going to put on where are these instructions? That's her talking about the arguments about it. Let's see. Okay. I'm going to remove myself. I want to, there should be a poll. I'm going to put the poll up, but I'll give it some time. I just need to take a little bit of a break from screen time. Okay, read carefully. So, the only thing is I don't remember the exact charges. Okay, so I've got guilty on all, not guilty, guilty of lessers. So you need to listen to it before. Yes, listen properly. Wait, let's do it for our new friends. This is South Africa's ex-president.
Our membership figures stood at 700, listen properly, 769,820 and 70 members, down from 100.2 million in 2012.
Okay, so we're not in verdict watch yet. They're having lunch. I don't know the lessers for sure because I missed the jury instructions, but from the notes I was taking last night, it was likely going to be voluntary manslaughter or involuntary. Judge took self-defense off the table. However, she said that, from my understanding, there wasn't enough for malice for it to be taken off.
There was some few word changes that I made when I put in the accidental instruction into the A and B. And I did add another sentence with regard to no emotional response to the, I didn't add the whole thing, but I added another sentence with regard to no emotional response on the graphic photos. Other than that, the rest of it went seamlessly, hopefully.
We marked the transcript from June 19th of 2024 as I for identification. We marked the second version of that same transcript as J for identification. We marked the thumb drive of the recording of the interview as K for identification. We marked the unredacted exhibit, which was marked as 57, which was the South Shore Hospital medical records. The unredacted copy was marked L for identification. The unredacted version of exhibit number 14, which exhibit number 14 was the video, which is on a CD. That unredacted version was marked as M for identification, and then the original death certificate, which was exhibit number 56, is marked N for identification. And the redacted version of exhibit 14 and 56 and 57 were swapped out. So those should be all set.
All right, thank you. That's that. I got word on the closings, and that's absolutely fine.
Testing run, but are we gonna receive a physical copy of the changed instructions, of revised instructions?
Yes, Madam Clerk, you can do that with the redaction to the appropriate page. Yes, it'll be easier for you to follow along.
Page 37, Madam Clerk.
Here. All persons aiding before this hour of justice, thy impediment. Justice of the Superior Court, now sitting in the Commonwealth. Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This honorable court is now in session. Please be seated.
Good morning, Your Honor. May I proceed?
Good morning, Len.
Good morning, everyone.
Good morning.
Before the court is the continuation of the jury trial matter, Commonwealth versus Christine Ricci. Ms. Ricci is present, is represented by attorneys Joshua Wood and Maura Barry. The Commonwealth is represented by Assistant District Attorneys Jeremy Kuzman, Shannon Buckingham, and Jason Moran.
Good morning, jurors. Jurors, will start today with your answer to my 3 questions. Jurors, were you able to comply with my order that you not speak to anyone about this case?
Yes.
And were you able to abide by my order that you not do any research about the case?
Yes.
Do you all still have open minds?
Yes.
With those affirmations, we are ready to start today's work. As you know, the close of yesterday, the Commonwealth closed its evidence in the case. As you also know, the defense has no burden in the case. All the burden rests with the Commonwealth of Massachusetts to prove its case beyond a reasonable doubt. The defense does get the opportunity, if she wishes, to put on defense. Attorney Wood.
Defense rests.
Okay. I'll see counsel decide on the bottom. So with that, jurors, the defense rests. That means that you've heard all the evidence you're going to hear in this case, and we're going to move on to the important last 2 parts of this trial. Those last 2 parts comprise my instruction to you. Sometimes I call it the charge to you. It's the formal description for it. And then the attorney's closing arguments. Just to give you some time frame, the charge is long. You're going to get it orally. And then I will give it to you also in writing so that you can use it when you deliberate the case. If at any point you feel that you're losing your attention and you need me to give you a break, you let me know. The closing arguments are also quite involved and will take some time. At any point, hopefully not during the closing arguments, but before you know those closing arguments are going to start, if you need a break, again, let me know. What's paramount to everybody in this courtroom is that you're able to keep your attention on what I'm saying and what the attorneys are saying at a later point today. I want to thank you for your jury service on this case. Jury service is an important part of our democratic self-government. You're responsible for upholding the law and our principles of justice. That's what you promised to do at the beginning of the trial when you took your oath as jurors. I want to thank you for your time, your attention, and your patience throughout the trial. You've all devoted a substantial amount of time to this case, time away from your personal lives, your studies, your work, your families, to sit as jurors in this case and to decide the very important matter now at issue between the Commonwealth and the defendant, Christine Ricci. You have done so in accordance with the finest traditions and the highest aspirations of our system of justice, and I thank each of you for your service and your sacrifice. You must now carefully consider all of the evidence decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt that Ms. Ricci is guilty of the crimes charged in this case. As I said, the final steps in this trial will take place in 3 different steps. First, I am going to give you the instructions now about the law that is specific to the charges in this case. After I do that, the attorneys will make their closing arguments, where they will highlight the evidence that they think is important and will argue in favor of the conclusions they ask you to reach. The defense will argue first, and the prosecution will argue last. After the closing arguments, I will give you more generalized instructions and will help guide you through your evaluation of the evidence and your decision-making and deliberations in this case. You will then work together to reach a verdict. Please pay careful attention to my instructions. All of my instructions are important, and you must follow all of them, even if you do not agree with them. To make sure that I give these instructions accurately, as you know, I am largely reading these instructions. That's deliberate. You will also get a written copy to refer to in the jury room during your deliberations. Due to the length of the charge, I'll be sending in a copy for each of you to use while you deliberate the case. I'm going to do my best to make sure that the instructions that I give you now orally match with those written instructions. If there is anything different between what I say aloud and what is in the written instructions, please follow my oral instructions now. Let me start with the prosecution's burden of proof and the presumption of innocence. There is a fundamental rule that applies in every criminal case, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Ricci is presumed innocent of the charges in this case. That means you must consider Ms. Ricci to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at the trial that Ms. Ricci committed the crimes charged. And I will explain what I mean by reasonable doubt in a moment. Ms. Ricci does not have to do anything to convince you she is innocent. She does not have to explain anything. Ms. Ricci does not have to testify, call or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Ricci beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Ricci's guilt on a particular charge, then your verdict should be not guilty on that charge. You may find Ms. Ricci guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. So the burden is on the Commonwealth to prove beyond a reasonable doubt that Ms. Ricci is guilty of the charges made against her. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it's not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you've compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we refer to the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecution. If you evaluate the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what I mean by proof beyond a reasonable doubt. So let's now discuss what the prosecution must prove. There are two indictments or charges in this case, and you must decide whether Ms. Ricci is guilty of those charges. For each of the charges, there are certain things, we call them elements, that the Commonwealth must prove beyond a reasonable doubt to show that Ms. Ricci is guilty. And I will explain these legal rules to you now. First, indictment 001, charges murder. There are two different degrees of murder. Murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. The Commonwealth alleges that the defendant committed murder in the first degree on two theories. First, murder with deliberate premeditation, and second, murder with extreme atrocity or cruelty. To find the defendant guilty on either of these theories of murder, you must be unanimous. That is, all the deliberating jurors must agree that the Commonwealth has met its burden of proving every required element on that theory beyond a reasonable doubt. You should check the appropriate box or boxes on the verdict slip as to each theory on which you agree unanimously. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt on either of these theories of first-degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. If you are unable to agree unanimously that the Commonwealth has met its burden to prove beyond a reasonable doubt that the defendant is guilty of murder in the first degree or murder in the second degree, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of the lesser offenses of voluntary manslaughter or involuntary manslaughter. And I'll begin on instructing you on the elements and the additional requirements of proof for each of these theories of murder in the first degree with deliberate premeditation. I will next instruct you on the second theory of murder in the first degree. I will next instruct you on murder in the second degree. I will then instruct you on voluntary manslaughter and involuntary manslaughter. Finally, I will instruct you on indictment 002, the charge of assault and battery with a dangerous weapon. And then I will review the verdict slips with you. Let me start first with murder with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following four elements. First, that the defendant caused the death of Michael Ricci Sr. Second, that the defendant intended to kill Michael Ricci Sr. That is, the defendant consciously and purposefully intended to cause Michael Ricci Sr.'s death. Third, that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. And fourth, in addition to these elements, the Commonwealth must prove that there were no mitigating circumstances. I will now discuss each of these requirements in more detail. As to the first element is that the defendant caused the death of Michael Ricci Sr. A defendant's act is the cause of death, where the act, in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended to kill Michael Ricci Sr. That is, the defendant consciously and purposefully intended to cause Michael Ricci Sr.'s death. If you have a reasonable doubt as to whether Michael Ricci Sr.'s death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved this element of intent to kill the victim. The third element is that the defendant committed the killing with deliberate premeditation. That is, she decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from the decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. In deciding whether the defendant intended to kill Michael Ricci Sr. and whether she formed that intent with deliberate premeditation, you may consider any credible evidence that the defendant suffered from a mental impairment. A defendant may form the required intent and act with deliberate premeditation even if she suffered from a mental impairment. But you may consider such evidence in determining whether the Commonwealth has proved this element. The fourth element of the charge of first-degree murder on a theory of deliberate premeditation is that the Commonwealth is required to prove beyond a reasonable doubt that there were no mitigating circumstances. The law recognizes that in certain circumstances, which we refer to as mitigating circumstances, the crime is a lesser offense than it would have been in the absence of the mitigating circumstance. A killing that would otherwise be murder in the first or second degree is reduced to the lesser offense of voluntary manslaughter if the defendant killed someone under mitigating circumstances. Not every circumstance you may think to be mitigating is recognized as mitigating under the law. In this case, the mitigating circumstances that you must consider are heat of passion on reasonable provocation and heat of passion induced by sudden combat. To prove that the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt that there were no mitigating circumstances. And I will instruct you on each of these mitigating circumstances in more detail later when I discuss voluntary manslaughter. Moving next on to the second theory of first-degree murder, murder with extreme atrocity or cruelty. You shall consider this theory of murder in the first degree, regardless of whether or not you find the Commonwealth has proved murder in the first degree with deliberate premeditation. To prove the defendant guilty of murder with extreme atrocity or cruelty, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused the death of Michael Ricci Sr. Second, that the defendant either A, intended to kill Michael Ricci Sr., or B, intended to cause grievous bodily harm to Michael Ricci Sr., or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. The third element under this theory is that the killing was committed with extreme atrocity or cruelty. In addition, the fourth element is, in addition to these the first three elements, the Commonwealth must also prove that there were no mitigating circumstances. And I'll discuss each of these requirements now in more detail. The first element is that the defendant caused the death of Michael Ricci Sr. The defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant, as I said, A, intended to kill Michael Ricci Sr., or B, intended to cause grievous bodily harm to Michael Ricci Sr., or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would occur. As you can see, the second element has three sub-elements, which I will call prongs. And the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. Moving to that second prong under this theory, the second prong is that the defendant intended to cause grievous bodily harm to Michael Ricci Sr. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether the victim's death was accidental, because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from a mental impairment. The third element is that the killing was committed with extreme atrocity or cruelty. Extreme atrocity means an act that is extremely wicked or brutal, appalling, horrifying, or utterly revolting. Extreme cruelty means that the defendant caused the person's death by a method that surpassed the cruelty inherent in any taking of a human life. You must determine whether the method or mode of a killing is so shocking as to amount to murder with extreme atrocity or cruelty. The inquiry focuses on the defendant's actions in terms of the manner and means of inflicting death, and on the resulting effect on the victim. In deciding whether the Commonwealth has proved beyond a reasonable doubt that the defendant caused the death of the deceased with extreme atrocity or cruelty, you must consider the following three factors. First, whether the defendant was indifferent to or took pleasure in the suffering of the deceased. Second, whether the defendant's method or means of killing the deceased was reasonably likely to substantially increase or prolong the conscious suffering of the victim. Or 3, whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person. In considering whether the means used by the defendant were excessive and out of proportion to what would be needed to kill a person, you may consider A, the extent of the injuries to the deceased, B, the number of blows delivered, C, the manner, degree, and severity of the force used, and D, the nature of the weapon, instrument, or method used. You cannot make a finding of extreme atrocity or cruelty unless it is based on one or more of the 3 factors I just listed. A murder committed by a single blow may be extremely cruel or atrocious where there is evidence of one or more of these 3 factors. You may consider the defendant's mental condition at the time of the killing, including any credible evidence of mental impairment, in determining whether the Commonwealth has proved beyond a reasonable doubt that the defendant committed the killing with extreme atrocity or cruelty. In addition to these elements, the Commonwealth must also prove that there were no mitigating circumstances. And I have already mentioned that I will instruct you on mitigating circumstances later when I discuss voluntary manslaughter. Now I will turn to murder in the 2nd degree. In order to prove murder in the 2nd degree, the Commonwealth must prove the following elements. First, that the defendant caused the death of Michael Ricci Sr. Second, that the defendant A, intended to kill Michael Ricci Sr., or B, intended to cause grievous bodily harm to Michael Ricci Sr., or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known, created a plain and strong likelihood that death would result. Third, in addition to these first 2 elements, Commonwealth must also prove that there are no mitigating circumstances. If the Commonwealth proves all of the required elements, but fails to prove beyond a reasonable doubt that there are no mitigating circumstances, you must find the defendant not guilty of murder, but then you shall return a verdict of voluntary manslaughter. The requirements of proof for murder in the 2nd degree are the same as the elements for murder in the 1st degree with extreme atrocity and cruelty, but without the element that the killing was committed with extreme atrocity or cruelty. Moving now to voluntary manslaughter. To prove the defendant guilty of murder in the 1st or 2nd degree, the Commonwealth is required to prove beyond a reasonable doubt that there were no mitigating circumstances that reduce the defendant's culpability. A mitigating circumstance is a circumstance that reduces the seriousness of the offense in the eyes of the law. A killing that would otherwise be murder in the 1st or 2nd degree is reduced to the lesser offense of voluntary manslaughter where the Commonwealth has failed to prove that there were no mitigating circumstances. Therefore, if the Commonwealth proves all of the required elements of murder, but fails to prove beyond a reasonable doubt that there were no mitigating circumstances, you must not find the defendant guilty of murder, but you shall find the defendant guilty of voluntary manslaughter. I will now instruct you on each of these mitigating circumstances. Let me pause to get some water. The first mitigating circumstance is heat of passion on reasonable provocation. Heat of passion includes the states of mind of passion, anger, fear, fright, and nervous excitement. Reasonable provocation is provocation by the person killed that would be likely to produce such a state of passion, anger, fear, fright, or nervous excitement in a reasonable person as would overwhelm his or her capacity for reflection or restraint, and did actually produce such a state of mind in the defendant. The provocation must be such that a reasonable person would have become incapable of reflection or restraint and would not have cooled off by the time of the killing, and that the defendant herself was so provoked and did not cool off at the time of the killing. In addition, there must be a causal connection between the provocation, the heat of passion, and killing. The killing must occur after the provocation and before there is sufficient time for the emotion to cool, and must be the result of the state of mind induced by the provocation, rather than by a pre-existing intent to kill or grievously injure, or an intent to kill formed after the capacity for reflection or restraint is returned. Mere words, no matter how insulting or abusive, do not ordinarily by themselves constitute reasonable provocation. Reasonable provocation does not require physical contact, but physical contact, even a single blow, may amount to reasonable provocation. Whether the contact is sufficient will depend on whether a reasonable person under similar circumstances would have been provoked to act out of emotion rather than reasoned reflection, and on whether the defendant was in fact so provoked. The heat of passion must also be sudden. That is, the killing must have occurred before a reasonable person would have regained control of his or her emotions, and the defendant must have acted in the heat of passion before she regained control of her emotions. If the Commonwealth has not proved beyond a reasonable doubt the absence of heat of passion on reasonable provocation, the Commonwealth has not proved that the defendant committed the crime of murder. Next, I want to talk about heat of passion induced by sudden combat. Sudden combat involves a sudden assault by the person killed and the defendant upon each other. In sudden combat, physical contact, even a single blow, may amount to reasonable provocation. Whether the contact is sufficient will depend on whether a reasonable person under similar circumstances would have been provoked to act out of emotion rather than reasoned reflection, and on whether the defendant was in fact so provoked. The heat of passion induced by sudden combat must also be sudden. That is, the killing must have occurred before a reasonable person would have regained control of his or her emotions, and the defendant must have acted in the heat of passion without cooling off at the time of the killing. If the Commonwealth has not proved beyond a reasonable doubt the absence of heat of passion induced by sudden combat, the Commonwealth has not proved the defendant committed the crime of murder. In summary, a killing that would otherwise be murder is reduced to the lesser offense of voluntary manslaughter if the defendant killed someone because of heat of passion on reasonable provocation or heat of passion induced by sudden combat. The Commonwealth has the burden of proving beyond a reasonable doubt that the defendant did not kill as a result of heat of passion on reasonable provocation or heat of passion induced by sudden combat. If the Commonwealth fails to meet this burden, the defendant is not guilty of murder, but you shall find the defendant guilty of voluntary manslaughter if the Commonwealth has proved the other required elements. Let me next move to involuntary manslaughter. Involuntary manslaughter is the unlawful killing unintentionally caused by wanton or reckless conduct. Wanton or reckless conduct is intentional conduct that created a high degree of likelihood that substantial harm will result to another person. Wanton or reckless conduct usually involves an affirmative act. An omission or failure to act may constitute wanton or reckless conduct where the defendant has a duty to act. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused Michael Ricci Sr.'s death. Second, that the defendant intended the conduct that caused Michael Ricci Sr.'s death. And third, that the defendant's conduct was wanton or reckless. I'll now discuss each of these elements in more detail. The first element is that the defendant caused the death of Michael Ricci Sr. As stated earlier, a defendant's act is the cause of death, where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause death. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is a conduct involving a grave risk of harm to another person, undertaken with indifference to or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of grave danger. Even if the defendant herself did not realize the grave risk of harm to another, the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It's not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I've defined that term. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant suffered from a mental impairment. A defendant may have the requisite knowledge, even if she suffered from a mental impairment, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now I'm going to give you supplemental instructions on indictment, the charge of indictment 001. First, definition of death. Death occurs when the heart has stopped long enough to result in complete and permanent loss of brain function. This complete and permanent loss of brain function occurs when, in the opinion of a licensed physician based on ordinary and accepted standards of medical practice, there has been a total and irreversible cessation of spontaneous brain functions, and further attempts at resuscitation or continued supportive maintenance would not be successful in restoring such functions. Next, use of a dangerous weapon. As a general rule, you are permitted, but not required, to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to her or him, a reasonable person would know creates a plain and strong likelihood that death would result. The third supplemental instruction regards your obligation on guilt or innocence. If the evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense, you have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of any offense charged, you must find her not guilty. Moving now to indictment 002, assault and battery with a dangerous weapon. In indictment 02, the defendant is charged with assault and battery on Michael Ricci Sr. by means of a dangerous weapon on January 28, 2021. The Commonwealth may prove a person guilty of assault and battery by means of a dangerous weapon based on two theories: intentional or reckless conduct. I'll first instruct you on intentional assault and battery by means of a dangerous weapon. To prove Christine Ricci guilty of intentional assault and battery by means of a dangerous weapon, the Commonwealth must prove 4 elements beyond a reasonable doubt. First, that the defendant touched Michael Ricci Sr. Second, that the defendant did so by means of a dangerous weapon. Third, that the defendant intended to touch Michael Ricci Sr. And fourth, the touching was not justified. As to the first element, the Commonwealth must prove that the defendant touched Michael Ricci Sr. A touching is any physical contact, however slight. Second, the Commonwealth must prove that the defendant touched Michael Ricci Sr. by means of a dangerous weapon. A dangerous weapon is any object that is, by its design or how it is used, can cause serious
Oh my God, I am Elaine today.
I was gonna see if the setting bench might be easier that way.
So what I said is I think they just come back and then go to lunch. No, bailiff sits. I can see the first one. It's the back that's confusing. And the back one, it's quite hard to explain, but it was almost like if you picture a small, like a BB gun bullet. And it was like here. Really weird. Psychosaurus, I got it from, well, actually, Vaughan got this one from a shop called Pip, which you guys won't have. But it's very lightweight and they move it around a lot. We got it because we need to get the professional carpet cleaning people out. But the weather's been so cold and rainy that it hasn't made sense. So we just lay it on top of another carpet for now. And as you can see, they're having a grand time playing Magic Carpet Ride. No online store, and they are local. But you can probably find something like it, something similar, if you use Google Photos. You just screenshot and then search in Google Lens. Also, like, it was super cheap, so I don't think paying shipping that far would make sense. Don't really know what's happening in this court. Do, 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 do. Riveting. Let's go back to this.
Bodily injury or death. For instance, an object such as a gun, dagger, sword, or the like is a dangerous weapon based on its designed purpose to cause serious bodily injury or death. Another object, such as a pocket knife, baseball bat, shoe, or even pencil, that is not designed to cause injury or harm, becomes a dangerous weapon if a person uses it to cut, strike, or otherwise touch someone in a way that a reasonable person would recognize could cause serious bodily injury or death. The third element, intended to touch, requires you to consider the defendant's state of mind. A person intends to touch if the person means to touch, as opposed to doing it accidentally or carelessly. The Commonwealth does not have to prove that Christine Ricci intended to harm Michael Ricci Sr., but the Commonwealth must prove that the defendant meant to touch Michael Ricci Sr. with a dangerous weapon. If you have a reasonable doubt as to whether the touching of Michael Ricci Sr. was accidental, because the touching was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find the Commonwealth has proved this element of intent to touch Michael Ricci Sr. As to the fourth element, the law accepts certain touchings as justified, even if done with a potentially dangerous weapon. For example, when a doctor performs a surgery or when a person consents to expected contact by playing certain sports, the Commonwealth must prove the touching was not justified. The second theory of assault and battery by means of a dangerous weapon is reckless assault and battery by means of a dangerous weapon. To prove the defendant guilty of assault and battery by means of a dangerous weapon by reckless conduct, the Commonwealth must prove 4 elements beyond a reasonable doubt. First, that the defendant acted recklessly. Second, that the defendant intended to do the act. Third, that the defendant's reckless act caused Michael Ricci Sr.'s bodily injury. And fourth, the bodily injury was done by means of a dangerous weapon. As to the first element, the Commonwealth must prove that the defendant acted recklessly. A person who acts recklessly does something even though she knows or should have known that her action is very likely to cause substantial bodily injury to another person. It is not enough for the Commonwealth to prove that Ms. Ricci was careless or negligent, or that she did not act reasonably. The Commonwealth must prove that Ms. Ricci recognized, or a reasonable person in her position would have recognized, that her actions were so dangerous that they were very likely to cause substantial bodily injury to someone else. But Ms. Ricci nonetheless went ahead anyway. The Commonwealth does not have to prove that the defendant intended to strike or hurt anyone, or that she expected anyone would be hurt. As to the second element, the Commonwealth must prove that Ms. Ricci conscientiously decided to do the act and that she did not do it accidentally. I refer you to my earlier instruction above as to the definition of accidental, which I gave you in the first instruction on assault and battery, dangerous weapon, intentional. The Commonwealth does not have to prove that Ms. Ricci intended to injure or touch Michael Ricci Sr. As to the third element, the Commonwealth must prove that Christine Ricci's reckless act caused Michael Ricci Sr. bodily injury. Bodily injury is injury that is serious enough to hurt Michael Ricci Sr. or interfere with Michael Ricci Sr.'s health or physical welfare. Bodily injury is something that does more than just shake Michael Ricci Sr. up, or cause Michael Ricci Sr. minor discomfort. It must be more serious than that, but it does not have to cause permanent injury. As to the fourth element, the Commonwealth must prove that the bodily injury was done by means of a dangerous weapon. I refer you to the definition of dangerous weapon that I previously gave to you under the theory of intentional assault and battery with a dangerous weapon. The Commonwealth must prove that the bodily injury was done by Ms. Ricci using a dangerous weapon, causing a dangerous weapon to come in contact with Michael Ricci Sr., or causing Michael Ricci Sr. to come into contact with a dangerous weapon. The jurors, I'm going to ask you to please stand up and stretch. Right, I'll move to the closing argument.
Try that again. That's the end of the jury instructions. So what? So we've got murder 1 or 2. Voluntary or involuntary. Mm. Um, assault and battery. Okay, I don't know what they're, if they're on, let me show you. They can't still be sidebarring. So they basically choose like, they basically choose any degree of the charges that are in the description. That is wild. And the one thing that they were debating yesterday, so they took out self-defense, but they were debating malice and intent, which is the voluntary and involuntary. I thought from what they were talking about, that was going to be for the jury instructions to choose before, not just like, hey, you choose. Which one do you want? It's like an a la carte menu of charges. Exactly. Like the way that they were discussing why each option should be there, my presumption was, well, we need to give the jury one or the other, not like we'll give them both and they can decide. I think we need to watch some, just like Judge Fleischer or something in the meantime. Because this is, I don't know what they're side buying. We can watch yesterday's one because I don't like to watch live. I want people to still go to the channel and watch the live there.
Hi.
That's for Bueno. I just got notified that they can do it tomorrow.
Wonderful, great. Now, that's a good question because we get the TRAS done quick. Results, that's another question, right?
Results would be done by Friday, so I would say maybe Monday.
Really? You think of that quick?
I would think it since it's expedited.
Great, okay, yeah, set it for Monday. And then, wait, did I give you Cedric's phone number?
No.
Can I give that to you? Do you mind reaching out to him? You know what? I emailed him yesterday before we left. I wonder if he replied. Victoria, do you know if he replied? I CC'd you on the email too. Let's see. No. Today's what, Wednesday? Right? Okay, you ready? Let me just give you this phone number. This is his cell phone, okay? 713-702-1574. His name is Cedric Taylor, works for the Los Angeles, or no, he works for TLC Wellness, right? But perhaps he knows how and if we can get Mr. Bueno into this housing place.
I'll reach out today, yeah.
We tried to call, Logan and I tried to call this housing complex yesterday and like the number wasn't working. I don't know, but he replied and so.
I did try to call the number you gave me multiple times. I haven't got anything. But I'll reset him for Monday. And
does he know who that was?
What time are they coming? Flip, by the way.
Yes.
Matter of fact, you have that for me. Okay, great. This doesn't have it, does it?
Judge Carpona, so I didn't know.
Yeah, no.
This court's now accessed to be seated, please.
Jurors, welcome back. So jurors, you've now heard the final arguments of counsel, and I'm going to provide you with some general instructions and then some rules and guidelines relating to your deliberations. Let me start where we began with your preliminary instructions as to reminding you of the functions of everyone that's in this courtroom. My function as a judge in this case has been to see that this trial was conducted in a fair and orderly manner. It's my responsibility to rule on what you consider as evidence, to instruct you on the law that applies to this case. You should not consider anything that I have done or said during this trial in ruling on any motions or objections or in comments to the attorneys or to the witnesses or in setting forth the law in these instructions as any indication of how you should decide this case. If you believe that I have expressed or even hinted at any opinion about the facts of this case, please disregard it. I have no opinion about the facts of this case or what your verdict ought to be. That is solely and exclusively your duty, your responsibility. It was a duty of the lawyers when the other side offered evidence that he or she believed was not admissible under our rules of evidence to object. The lawyers have an obligation to ask to speak to me at the side of the bar about questions of law, which the law requires me to rule on outside of your hearing. When the attorney felt in his or her professional judgment that a question or answer violated those rules of evidence, he or she has a duty to object, and then it's my responsibility to rule on that objection. The rules of evidence are structured to ensure that the jury only hears evidence that is relevant and material to some issue involved in this case. You should not draw any inference, favorable or unfavorable, to any of the attorneys or their clients for objecting to the proposed evidence or asking me to make those rulings. That is their function and their duty as attorneys. Let me next turn to your function. Your function as the jury is to determine the facts of this case. You are the sole and exclusive judges of the facts of this case. You alone determine what evidence to accept, how important is any evidence is that you do accept, and what conclusions you draw from all of the evidence. You should determine the facts solely on a fair consideration of the evidence. You are to be completely fair and impartial. You are not to be swayed by prejudice, by personal likes or dislikes towards either side, or by any personal view you may have as to the nature of the claims in this case. You are not to decide this case based on anything you may have read or heard outside of the courtroom. You are to confine your deliberations to the evidence and nothing but the evidence. Your verdict must be based solely on the facts as you find them from the evidence and on the law as I explain it to you. Nothing else that may have happened in or outside of this courtroom is relevant to your deliberations or your verdict. I want to turn to the issue of fairness. Each of you has taken an oath and promised in that oath to be fair. And I'm sure you each want to be fair, but it's not always easy. Part of being fair is being willing to examine your decision-making process. To be sure that you base your decisions as jurors only on the evidence and the law. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them. We all have them simply because we are human. They affect our actions and decisions without us even realizing it. As a judge, I have the same problem as everyone else. So let me share a few strategies that I found useful. These strategies will help make sure that you decide this case based only on a careful examination of the evidence and on the legal rules that I've explained to you. First, slow down. Do not rush to a decision. Take time to consider all of the evidence. Quick decisions are more likely to reflect stereotypes or assumptions about people that we may not even be aware of. Second, as you start to draw conclusions, consider not only the evidence that supports your conclusions, but also think carefully about any evidence that undermines or weakens those conclusions. Third, as you think about the people involved in this case, ask yourself, would my decision be different if the people were different? For example, what if the people involved were in different social or economic groups, or had different ages, genders, gender identities, or sexual orientations, or came from different racial or ethnic backgrounds? Fourth, listen to each other. Often other jurors may have different points of view. If so, they may help you make sure that you're focusing on the facts. Of course, other jurors could be influenced by their own unstated assumptions, so don't hesitate to share your own views. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you think is important. When you explain your thoughts to other jurors, you help everyone focus on the evidence. If you do these things, you will do your part to reach a decision that is as fair as is humanly possible, and that's your responsibility as jurors. So, what counts as evidence? Three things. The sworn testimony of the witnesses that you heard here in court from the witness stand, the exhibits, that is the documents, photographs, and other items that were admitted into evidence, which will be sent into the jury room with you. And third, the party stipulations or agreements to certain facts. As to the stipulated facts, you can take those as true. Oral or testimonial evidence has no greater or lesser weight than documentary evidence. You, the jurors, will decide how to evaluate the evidence, that is, what weight to put on it. The quality or strength of the proof is not determined by the sheer volume of evidence or the number of witnesses or exhibits. It is the weight of the evidence, its strength intending to prove the issues at stake that is important. Some things that have occurred during the course of this trial are not evidence, and you may not consider those things in deciding the facts of this case. A question put to a witness is never evidence. Only the answers are evidence. If a witness agrees with a factual assertion contained in a question, then the assertion agreed to is evidence. However, if a witness disagrees with a proposition contained in a question or doesn't respond to it, then that proposition is not in evidence simply because it was suggested in a question. You must look elsewhere for evidence about that issue. In fact, nothing the lawyers have said is evidence. If I sustained an objection to a question put to a witness, that is, if I didn't allow the witness to answer that question, you're to disregard that question and you must not speculate about what the answer might have been. Also, you may not consider any question or answer or evidence that I struck from the record. The opening statements and the closing arguments are important and they're helpful, but they are not evidence in this case. You are not to decide this case on conjecture or speculation, but on the evidence as you remember it and the reasonable inferences that flow from that evidence. The personal beliefs of any of the attorneys, if any was expressed during the course of this trial on any issue, that isn't evidence either. And anything that you saw or heard outside of this courtroom about this case is not evidence. my instructions to you on the law that I'm now giving you, and anything again that I have done or said as a judge in passing during the course of the trial, that is not evidence either. There are two types of evidence which you may use to determine the facts of this case, and they're direct evidence and circumstantial evidence. Direct evidence is where we have a witness that's testified directly about the fact that is sought to be proved based on what he or she claims to have seen or heard or felt with his or her own senses. And the question there is whether you believe that witness or you don't. Circumstantial evidence is where no witness has directly testified about the fact that is sought to be proved. Instead, you've been presented with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. An inference is a permissible deduction that you make from evidence that you have accepted as believable. Inferences are things that you do every day. Little steps in reasoning in which you take some known information, apply your common sense in good reasoning to it, and then you draw a conclusion about it. You may draw an inference, even if it is not necessary or inescapable, so long as it is reasonable and warranted by the evidence. Let me give you an example of an inference. If someone in my household tells me that they saw the postal carrier put mail in my mailbox on a particular day, that is direct evidence that the mail was delivered. The person said they saw it. If I go out to my mailbox and I find mail that was not there the day before, I can infer that the postal carrier delivered mail that day. That is circumstantial evidence that the mail was delivered, although no one saw the postal carrier actually delivering the mail. The law allows both direct and circumstantial evidence, and there's no distinction to be given between the two. Let me talk about witness credibility. Your function, among others, is to decide the credibility of the witnesses. In determining credibility and the weight to be given to the testimony of each witness, you should consider, and you may be guided by such matters as the conduct and demeanor of the witness while testifying, the frankness or lack of frankness of that witness, the reasonableness or unreasonableness of the witness's testimony, the probability or improbability of that testimony, the witness's opportunity or lack thereof to see or know the facts about which he or she has testified, and the accuracy of the witness's memory. You may also consider the witness's motive to testify for or against either party, and of course, the interest or lack of interest of the witness in the outcome of the case. And you should also consider any bias that he or she may have shown in his or her testimony and determining the credit to be given to that testimony. Now, you have great power in this regard. In evaluating the evidence presented by a witness who has appeared here in court to testify, you, the jurors, are free to believe everything that witness says, some of what that witness says, or none of what that witness says. If there are any conflicts in the testimony, it is your function as the jury to resolve those conflicts and ultimately decide where the truth lies. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of different witnesses may or may not cause the jury to discredit such testimony. That's entirely up to you. Two or more persons witnessing an event may see or hear it differently, and innocent misrecollection, like a failure of recollection, is not an uncommon experience. In weighing the effect of a discrepancy, always consider whether it pertains to a matter of importance or an unimportant detail, and whether the discrepancy results from innocent error or intentional representation. After making your own judgment, you should give the testimony of each witness such weight as you think it deserves. Thus, you may accept or reject the testimony of any witness in whole or in part. That's entirely up to you. Let me next instruct you about expert witnesses. The term refers to witnesses who have medical, scientific, technical or other specialized knowledge, education, skills, training, or experience in a particular field. Generally, in cases that are tried in our courts, witnesses may testify only to the facts that are within their own personal knowledge. That is, things they've personally seen or heard or felt. However, in a variety of cases, issues arise that are beyond the experience of lay persons. And in those types of cases, we allow persons with such specialized knowledge, education, training, or experience. And those are called expert witnesses to testify, and to testify not only to the facts, but also to their opinions and the reasons for those opinions on issues that are within that witness's field of expertise and are relevant and material to the case. However, just because a particular witness has specialized knowledge, education, training, or experience in his or her field does not put that witness on a higher level than any other witness. And you are to treat the expert witnesses just like you would treat any other witness. In other words, as with other witnesses, it's completely up to you to decide whether you accept the testimony from an expert witness, including the opinions the witness may have given. It's also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from that expert's testimony. You are free to accept or reject the testimony and opinion of such a witness, in whole or in part, if you determine that the witness's opinion is or is not based on sufficient education and experience, or that the testimony of the witness was or was not motivated by some bias or interest in the case. You must also keep firmly in mind that you alone decide what the facts are. If you conclude that an expert's opinion is not based on the facts, as you find those facts to be, then you may reject the testimony and opinion of the expert in whole or in part. You must remember that expert witnesses don't decide cases. Juries do. In the last analysis, an expert witness is just like any other witness in this case, in the sense that you alone make the judgment about how much credibility and weight you give to that expert's testimony and what conclusions you draw from that testimony. You will have all of the exhibits that are in evidence with you in the jury room. You shall consider exhibit evidence in the same way as you would consider witness testimony. You must determine whether you believe what is contained or reflected in an exhibit, and if so, what weight it deserves. You will note that there are either white or black markings on some of the exhibits. We call those redactions, and you will see them on exhibits 14, 32, 33, 34, 57, and 56. 56 and 57. As I mentioned previously in my instructions to you, certain irrelevant information has been removed from those documents and other exhibits. You're not to speculate about what that irrelevant information is. Do not consider it in any way. The court has removed irrelevant material to ensure the evidence is presented in a fair manner. You are not to engage in any guesswork or speculation about what's been excluded from your view. You are to decide the facts only from the evidence which is before you. Let me turn next to the defendant's right not to testify. As you observed, Christine Ricci has elected not to testify at this trial. Under our law, she has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth. It is not up to Ms. Ricci to prove that she is innocent. You are not to draw any adverse inference against her because she did not testify. You are not to consider it in any way or even discuss it in your deliberations. You must decide, based solely on the evidence presented during the trial and the reasonable inferences you draw from that evidence, whether or not the Commonwealth has proved beyond a reasonable doubt that Ms. Ricci committed the crimes charged. I want to re-instruct you on other bad acts. The defendant is not charged with committing any crime other than the charges contained in indictments 01 and 02. You have heard testimony about other acts allegedly done by the defendant, to include her use of knives in the past, hitting Michael Ricci Sr., and interactions with Janine Bouchard. You may not take any testimony of such alleged acts as proof that the defendant committed the crimes charged, nor may you consider it as proof that the defendant has a bad character or a propensity to commit crimes. You may consider that testimony solely on the issues of the defendant's motive, state of mind, intent, preparation, pattern of operation, relationship with the victim, and absence of mistake. You may not consider this evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant committed these other acts, she must have also committed the offenses charged in the indictment. Next, I want to turn to consciousness of guilt. You've heard evidence suggesting that the defendant may have intentionally made false statements before, during, and after her arrest. If the Commonwealth has proved that Christine Ricci did make such false statements, you may consider whether such actions indicate feelings of guilt by her, and whether, in turn, such feelings of guilt may tend to show guilt on these charges. You are not required to draw such inferences, and you should not do so unless they appear to be reasonable in light of all the circumstances of this case. As to indictment 001, any potential inference regarding consciousness of guilt may be probative only as to whether an unlawful killing was committed, and it is not relevant to the question of malice. If you decide that such inferences are reasonable, it will be up to you to decide how much importance to give them. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, for such feelings are sometimes found in innocent people. Finally, remember that, standing alone, such evidence is never enough in itself to convict a person of a crime. You may not find the defendant guilty on such evidence alone, but you may consider it in your deliberations along with all of the other evidence. The next topic is rehabilitation by prior consistent statement. Normally, you may not consider any statement that a witness made in the past which is similar to that witness's testimony at trial. That rule rests in part on our common experience that saying something repeatedly does not necessarily make it any more or less true. But we make an exception to that rule when there has been a suggestion at trial that a witness may have recently invented or changed the witness's testimony. In determining how reliable a witness is who has been accused of recently inventing or changing the witness's testimony, you may consider any earlier statements that the witness made which are consistent with the present testimony. It is for you to say how important the consistency is, depending on when any earlier statement was made and any other circumstances you consider significant. The earlier statement is not itself evidence of the fact that is mentioned in it, but you may consider it only for the limited purpose of deciding how much belief or importance you will give to the witness's trial testimony. Let me next move to graphic photographs. The Commonwealth has introduced certain autopsy photographs which show the alleged victim. You saw them yesterday. You will have those photos with you during your deliberations. The photos are not pleasant. Indeed, they may be described as graphic. I instruct you that your verdict must not in any way be influenced by the fact that these photos are unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by those photographs. I instruct you that you must separate any emotional response from the value and weight of the evidence. Consider those exhibits only as they draw attention to a clinical medical status or to the nature of Michael Ricci Sr.'s injuries or to the nature of the incident itself. Next, I want to discuss search warrants. You heard some testimony about the police obtaining search warrants in the course of the investigation of this case. Like an indictment, the fact that a search warrant was obtained has no bearing on the defendant's guilt, and you may not consider that evidence as evidence of such. Now let me say a final few words about your deliberations. When you retire to the jury room to begin your deliberations, each of you should consider all of the evidence. Listen to the views of your fellow jurors and discuss the case with them in an effort to reach agreement regarding a true and just verdict. I urge you not to take an immediate straw vote to determine where each of you stand. Rather, I strongly encourage that you first review and analyze all of the evidence before anyone is asked to express their views regarding a verdict. Listen carefully and respectfully to your fellow jurors. The collective memories and insights of other jurors can help you in finding facts and coming to a verdict. Do not deliberate unless all of you are present and no one else is in the room. If one of you needs to leave for a moment, the rest of you should stop deliberating until that person returns. Do not hesitate to re-examine your own views and change them if you are persuaded that you are wrong. At the same time, each of you must decide this case for yourselves. Do not surrender your honestly held conclusions simply to arrive at a verdict. I have allowed each of you to take notes during the course of the presentation of the evidence in this case. That note-taking wasn't required, and it should not be considered by any of you as a verbatim transcript or record of what you may have seen or heard during the trial. When you retire to the jury room to deliberate your verdict, please remember that your notes are only an aid to your memory. They are not a substitute for what you actually remember as jurors. Whether you took notes or you did not, you must rely on your own memory of the trial and of the evidence when you're deliberating in the jury room. Do not be unduly influenced by the notes of other jurors. I am going to appoint a foreperson for your jury. The foreperson's vote or opinion is not entitled to any more weight than the vote or opinion of any other juror. Each member of the deliberating juror has an equal voice in the deliberations and an equal vote with respect to the verdict on the claims in this case. We have a foreperson for two reasons. First, to help you organize yourselves and to act as a facilitator of your discussions and deliberations. And second, to report your verdict on behalf of the jury in open court when you've reached a verdict. I am appointing juror number 139 in seat number 16 as the foreperson of this jury, and I thank you in advance for your additional service. To render a verdict in this case, you will be required to fill out verdict forms, and there are two verdict forms. To reach a verdict, all 12 deliberating jurors must agree as to the verdict that is recorded on the form. And when the jury has reached a verdict, the foreperson will fill out the appropriate answers, sign and date the verdict slips, and inform the court officer that the jury is ready to return to the courtroom. When we are assembled in the courtroom, the clerk will ask the foreperson for the jury's answers, and the foreperson will respond on behalf of the unanimous jury. I'm going to give you a little bit more instruction on that in a moment. That's the general procedure when you return to the courtroom. Only 12 persons are going to be deliberating in this case, and momentarily I'm going to reduce the jury. That means that I will randomly remove 3 jurors from the group and ask that those jurors stay to the side. Those alternate jurors will be kept separately, And I recognize that this may be frustrating to those jurors who are selected as alternate jurors. However, if an emergency occurs, we may need an alternate juror to take the place of a deliberating juror. And if so, I will instruct that the deliberations start again from the beginning. If fate makes you one of the alternate jurors, please don't take it personally. Your presence up and attention up until this point and your continuing availability, if you should be needed, is itself an important contribution to the administration of justice in this case. The court officers will make you as comfortable as possible while the jury deliberates the case. One important instruction: the alternate jurors should not discuss the case among themselves or with anyone else while the deliberating jurors are deliberating. And that is a simple reason, is as if you need to join the deliberating jury at any point, you can't have prior conversations with anyone else. So for the alternate jurors, rules that have been in place throughout this trial still stand. Don't speak to anyone about the case. Don't do any research about the case, and continue to have open minds. We're now going to reduce the hearing.
The following jurors will hereby be designated as alternate jurors and will be kept separate and apart from the other jurors in the attendance of the court officers unless drawn to replace the jurors. We have juror number 7 in seat number 2. We have juror number 64 in seat number 9, and juror number 111 in seat number 10.
Jurors, I know that you can't probably see what is here, but nonetheless, I'm going to orally give you some instructions with regard to the 2 verdict slips. There are 2 verdict slips, 1 verdict slip for indictment 001 and 1 verdict slip for indictment 002. As to the first verdict slip, you will see that up on the top, the offense is listed. And then the verdict slip really tracks the instructions as I gave them to you early this morning with regard to each of the decisions that the jury must find. And the verdict slip has the option for not guilty as the top, guilty of murder in the first degree, and the 2 theories are below that: by deliberate premeditation or by extreme atrocity and cruelty. Below that is guilty of murder in the second degree. Below that is guilty of voluntary manslaughter. Below that is guilty of involuntary manslaughter. So the verdict slip tracks very much the instructions that each of you will have, the order of the instructions that each of you will have. The verdict slip on offense number 2, assault and battery by means of a dangerous weapon, not guilty, or guilty of the offense as charged. It is important that jurors that you not communicate with anyone outside of the jury room about the deliberations or about anything concerning this case. If it becomes necessary during your deliberations to communicate with me, you may send a note through the court officer to me, signed by your foreperson, identifying the time of the note. I will then consult with the parties regarding the appropriate response and communicate that response to you. If you have any questions about testimony or evidence or the facts of this case, that we cannot help you with, as you are the sole judges of the evidence and the facts. But if you have a question about the law, as I have instructed you, that I will try to address as promptly as possible. If you do send me a note, Do not discuss anything to me about the content of your deliberations. Specifically, do not disclose to me or anyone else how the jury stands numerically or otherwise until after you have reached a unanimous verdict on the charges or have been discharged. Once you have completed your deliberations and arrive at a unanimous verdict as to the charges, the foreperson again will sign and date the verdict forms and notify the court officer that you've reached a verdict. Let me speak briefly about the actual process when you come back into this courtroom to return a verdict. When you return to the courtroom after reaching a verdict, the deliberating jury will remain standing. And we will ask your foreperson whether or not you have reached a unanimous verdict. And then the foreperson will say at that time, yes, we have. And then the court officer will take the verdict slip from the foreperson and give it to Madam Clerk, who will then give it to me. And I will review the verdict slips exclusively for the purpose of making sure that they've been filled in and signed and dated by the foreperson properly. I will then, having made that review, give the verdict slip back to the clerk, and it will be returned to the foreperson. The clerk will then ask the foreperson what the verdict is on each of the charges, and in response, the foreperson will read the jury's verdict. The clerk will then ask all of the deliberating jurors whether or not that, in fact, is your verdict. And if the foreperson is accurately stated the verdict, you will all answer yes. If she has not, of course, you will say no. Finally, I express no opinion with respect to how long or how short your deliberations should be. But I will say this, your deliberations must be as long or as short as it is necessary to reach a fair and just verdict. One last point before you begin your deliberations. Please have confidence in what you are about to do. You are all people of intelligence and common sense with many years of experience in the real world. Collectively, you bring to bear a very powerful force in determining the truth of the matters in controversy. Our system of trial by jury began centuries ago in England and has lasted largely uninterrupted to the present. If it had not proven to be a very powerful institution in providing justice, it would not have lasted for as long as it has. So, have confidence that working together, you will be able to arrive at a verdict in this case. And I am confident that you will each discharge your duties faithfully and well as jurors. I'm going to lead one last time to the counsel at the side of the bench. Court officers, they are going to be in charge of you during the deliberations. I ask you to listen carefully to the oath that they take.
Do each of you solemnly swear that you will take charge of this jury and keep them together in some convenient place until they have agreed, that you will not speak to them yourselves nor suffer anyone else to speak to them except by order of the court or to ask if they have agreed? So help you God. Do each of you solemnly swear that you will take charge of these alternate jurors and keep them in a convenient place, separate and apart from the other members, that you will not speak to them yourselves nor suffer anyone else to speak to them except by order of the court? So help you God. Thank you.
So, jurors, before you retire to the room to deliberate momentarily, the evidence will be brought in there. I'm not unaware of the time of the day. And so about 4 o'clock, you'll reach your first decision as a jury, which is I'm going to send in a note at 4 o'clock. And I do that pretty much every day while the jury is deliberating, asking what your wishes are. Generally, the trial day ends for the court staff at about 4:30, but we can, so 4 o'clock every day, I send in a note and say, do you want to stay until 4:30? Or do you want to go home? So that'll be the first decision that you're going to make, be in a few minutes. With that, jurors, I ask that you now retire and deliberate the case.
Court, rise for the jury. Jurors, please bring your notebooks and pens with you this time.
Instructions, mostly just minor edits, with the addition of the one additional instruction. I would expect, given the hour of the day that we're going to hear back at 4 o'clock, that they're ready to go home, but we'll deal with whatever answer they give us. I'll get that note to Madam Clerk. That'll also be marked as the next blank note that I send in at the end of the day. I mark that as the next exhibit for identification, which may be P. So I'll get that out as well. Make sure you take a final look at the exhibits, that everybody's content with what is in the exhibits. And I know that we have some video exhibits. You've probably heard me say this before, but please, please, please make sure that the computer that's going in there for them to play that is sanitized. I had a terrible experience in a prior case where something was on the computer. And so I ask that you both double check that we're not sending anything into the jury that would not be evidence in this case. 10-minute rule. That means that you always need to be within 10 minutes of the courthouse while the jury's deliberating. Anything else that I can address?
No, Your Honor, thank you.
No, Your Honor, thank you.
All right. Madam Clerk, let me know when that please ready to go.
Absolutely.
Court, all right.
Okay, so considering that is in 15 minutes, I don't really see the point, if I'm honest. Like, they're going to take the evidence into the room first, and then in 15 minutes, they're going to be like, are you wanting to stay or go home? Well, it's been 15 minutes, so anyway, what did I want to say? Yeah, because literally it is 3:44 p.m. As anticipated post-tooth, my sinuses, etc., are not happy. So fingers crossed that I don't land up getting sick from swallowing a broken tooth. But at least I mailed everything over. I anticipate that when I actually go to the specialist and have the tooth removed, I probably won't be able to stream for a day or two. But I will be very happy to have it done. They've been deliberating for 3 minutes 29. So I think what I'll do is I'm going to say goodnight because I want to still sort things out before I get into bed. And then when they come back at 4, or when they send a note back, I'll do a community post. So if they come back and say there's a verdict or something, then sure, I'll go live. But for now, it'll just be a community post, so keep an eye out for that. If the verdict comes in while it's my nighttime, then I'm going to have to cover it tomorrow. I'm hoping that they just say they want to go to bed and then we'll see them again tomorrow at 3 p.m. or whatever the time was. Oh, what woke you up, Winchester? Yeah, puppy. Let's see if she comes. Come, puppy. She doesn't want to move. Okay, I have set the portal up to go to RA. I will see you guys there to raid, and then I'll probably be going to bed. Well, I need to give the little one her meds and whatever. Yeah, notifications don't go out for community posts. Okay, excuse me. What is beep, 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 beeping? Can you guys hear that? Oh, that is so annoying. I used a stopwatch and it just beeped in my ear. So we're on 5 minutes, 8 seconds. I don't know which one I can use. It's not going to beep like that. All right. My eyes are so itchy now. I will see you guys tomorrow. I'll update you. And if somebody sees before I can, then before you see the community post, please feel free to tell in wherever you are, Discord, wherever. Thankfully, the tooth isn't sore right now. It's more just like my tonsils are not happy on most days. So when I think I might be getting a throat infection, I'm like, because obviously I need my throat. It was literally insured at a point. All right, good night. So nice to have so many new people. Thank you, everyone, for behaving. I will see you tomorrow. Bye.